Peace to the gods and goddesses. The god Shango back at you again, bringing the fire, not just of creation, but of justice. So buckle up, flesh fam, cause today we're diving deep into the murky waters of judge bias in the fight for a fair shake in the courtroom. You see, sometimes the scales just don't weigh out. Sometimes the scales, they just get tipped. Judges, the supposed guardians of impartiality, can find themselves with conflicts of interest or preconceived notions. The question is, when that happens, do they step aside? Today, we're talking about recusal refusal. Judge Glanville denies another recusal motion and digs his heels deep into the... When the judge digs their heels deep and refuses to recuse themselves from the case, even when there's a clear appearance of bias, is that justice? Hell no. We'll be breaking down the why and how of how recusal, the ramifications of biased judge, or aka judge bias, and what we can do as the flesh fam. So let's tap in, family. Without any further ado, let's get it started. We're going to start off with, finally, just a quick clip of how this all began. Hit the like, hit the follow, hit the subscribe. Appreciate you being here. Tap in, family.
Serving children. This is for the everyday citizen. They can keep looking. I'm not interested in them looking. They can look. I'm sorry they pissed off. Justice is now actually blind. Lady Justice is blind. Everybody can get it. Okay, so use that as your soundbite. I would tell them things are working. And so
finally say everybody could get it.
And not later than to account for that. Another sometimes odyssey happens until sometime on Monday evening. So when I started to read Mr. Steele's affidavit last night, we were put on notice that there was possibly another affidavit out there and another motion. So that's why we had to call you. Okay. So that's how we got here with this. Or did you all attempt to send me independently another a copy of that, or?
We did not, Judge.
Okay. No harm, no foul. No. So I just wanted to know if you had attempted to do so, because we would have certainly, had we known that, pulled you in on Monday morning, which would have been the closest time that I could have heard your particular motion. So just from a time aspect, I just wanted to account for that. Taking a look at, this applies to both motions that have been filed to recuse the court or disqualify the court. Recusal by a Superior Court judge is governed by Uniform Superior Court Rule 25, etc. Rule 25.1 provides that all motions to recuse and disqualify a judge presiding a particular case or proceeding shall be timely filed in writing, and all evidence thereon shall be presented by accompanying affidavit or affidavits, which shall fully assert the facts upon which the motion is founded. Filing and presentation to the judge shall not be later than 5 days after the affiant first learned of the alleged grounds for the disqualification, and not later than 10 days prior to a hearing or trial, which is the subject of the recusal or disqualification, unless good cause be shown for the failure to meet such time requirements, and that is cited in Georgia Uniform Superior Court Rule 25.1. So I'm applying that to both sets of motions to recuse. In applying this rule, Georgia courts have held that when a motion to recuse is filed, the trial judge shall immediately, 1, determine the timeliness of the motion, 2, the legal sufficiency of the affidavit, and 3, the legal sufficiency of the grounds, and has no power to do anything else, and that is Robinson versus the state, 332 Georgia Appeals at 240-241. The 3 threshold determinations that the trial judge must make in regard to a motion to recuse are whether it's timely filed, whether the affidavit made in support is legally sufficient, and whether some or all the facts set forth in the affidavit are true, recusal would be warranted, and that is Dacker versus the state, 300 Georgia, 74-77, 2016. The judge finds any 3 of the conditions have been met. No, I'm sorry, take that back, strike that. If the judge finds that all 3 conditions have been met, he must refer the motion to another judge to hear the motion, but if any one of the conditions is not met, there is no error in denying the motion. And motions to recuse are viewed and considered by the appellate court for abuse of discretion. Accordingly, the court is going to address each one of the factors as it pertains to both Mr. Steele's motion and, for shortness, Mr. Banks' motion. I find both motions were timely filed. I find that Mr. Steele's motion was in fact filed on this past Monday, which would have been the 17th of June. I find that Mr. Banks' motion on behalf of Ms. Bumpus was timely filed, as it was filed on the filed on the 14th of June at 10:40 p.m. Secondly, I find that in addressing the legal sufficiency of the affidavit, that means was it sworn? Was it sworn before a notary is in proper form? I find Mr. Williams and Ms. Bumpus's motions to be, or I should say affidavits, to be in proper form. The third thing that the court has to review, and like I said, I reviewed, is the legal sufficiency of your grounds of the motion. And here's where the court finds that upon a review of Mr. Steele's motion and affidavit, as well as Mr. Banks' motion and affidavit, that both contain assertions bare assertions and legal conclusions which aren't sufficient for the court to grant your motion at this point in time and refer it to another judge for it to be heard. So I'm going to deny the motion at this point in time. I invite you all to look at Baptiste versus the state. Just because adverse rulings have been made doesn't mean that the court stops the trial. So I'm going to make that. I'll reduce both of the motions to recuse to an order, and I will file that so you can take whatever steps you need to necessarily after that. But I don't get into anything about the affidavit itself, argument on that. I just have to read it. Those are the only 3 things I do. And then if I find it to be not sufficient on its face, I go for it. I just make the ruling at that point in time, let you all take it up. No, I won't grant a motion for a certificate for immediate review. And that's where we are at this point in time. Anything else, Mr. Banks?
If I could just briefly be heard, Judge.
Sure.
Well, please. And I'm not trying to. I understand the court's ruling, and we'll proceed as we see fit. I do take issue with the court's characterization about the legal insufficiency of the affidavits.
Well, that's why when it was reviewed on appeal,
sure,
it can certainly be. I mean, the appellate court will review my ruling for abuse of discretion.
Certainly
Okay.
understand that, Judge. And in stating that, Judge, I would just say that one of the issues that is raised in our affidavit, because our motion to recuse is to recuse you from the contempt proceeding, not the underlying criminal case in which Your Honor is presiding. And so we really don't have an issue or standing to even challenge that. And so to the extent that there is a contempt proceeding that is set for the 25th, Your Honor, you are a witness to that proceeding. And so because you were a witness. I
don't believe you. I'm not going to get into any argument.
Okay.
I can't. So that's your assertion at this point in time. And like I said, when that is taken up, I'll consider. I also remember I still need to rule on the issue of the motion to quash. So.
He said, I don't believe you.
So I may. That's your.
That is set for the 25th, Your Honor. you are a witness to that proceeding. And so because you were a witness.
I don't believe you. Well, I'm not going to get into any argument, but I can't. So that's your assertion at this point in time. And like I said, when that is taken up, I'll consider it. I also remember I still need to rule on the issue of the motion to quash. So I may, depending upon what I decide to do at that point in time, other things may be ripe. Okay?
Do you want to hear about the motion to quash, or you want to take
No, not yet, sir. I'm going to take up the motion to quash after I finish, we finish the direct of the current witness.
Okay.
And to other issues that have been raised, as I've told some of the other lawyers here, there is a transcript of what occurred in the ex parte matter. I will, in fact, I'll authorize defense counsel. I'll do a privilege review and see what needs to be disclosed in terms of impeachment and/or Brady, and for that, and I will do that. And then so if that pertained or if that issue affects you, then certainly that may be something that at the appropriate time you'll be able to have a look at.
Well, I appreciate the court's time. We would certainly rely upon our brief and our motion, and that's a part of the record.
Okay. All right, but I will reach out. The court will reach out to you on two things. One, the ability to take a look at the ex parte.
Basically, he's saying, don't call me, I'll call you.
Transcript and review it for the appropriate parts that the court will authorize. And then also for the, I'll re-notice you because I know that it's supposed to be done this Tuesday, but I doubt that we'll probably have it this coming Tuesday.
If I just may say, again, Judge, I know I've already said it as it concerns the issue about you being a witness to the proceeding. We don't believe that that's a bare allegation. We believe that would be an established fact at the hearing. We also.
But I can't take it. It's not something that I can argue with you at this point in time.
I'm not trying to argue.
No, sir. You are an advocate for your client. Sure. That's the only thing I can say, but I'm not going to take up that issue right now. It's part and parcel. You've made it part and parcel of the motion to recuse. So I'm saying that at this point in time, I've made my ruling. You've said what you need to say in terms of what your thoughts are. I'm going to reduce it to an order, and you can take what you want to after that, okay?
All right. Thank you.
All right. Thank you, sir. All right. Mr. Steele, similarly, I'll reduce what I have mentioned to in an order, and you will be able to take it up as you see fit. I'm not going to grant a motion to a certificate of immediate review. Anything else?
I have read Baptiste versus State. I've read all the cases that I believe are applicable. Best I can. But specifically, if the court would reconsider, and if nothing else, the Honorable Keith Adams and my joint affidavit in paragraph 12, we assert not a bare assertion or a legal conclusion, but we make facts that we specifically adopt from the Honorable Attorney Winchester, Collins, Banks, Nove, and Mormon's motion, where a person that they represent was in a meeting, ex parte, with the court and others, and the prosecutor and a witness, and specifically they wrote in a pleading and under Parrish, which is P-A-R-R-I-S-H versus State, which is 362 Georgia Appeal, 392 Division 1, 2022, the lawyer's pleading on behalf of the client becomes a statement of the client. And they said that this court got involved with speaking with Mr. Copeland and assisted in Mr. Copeland testifying against Mr. Williams. So I've added this court to the witness list. I plan on calling the court as a witness in the trial. I've added lawyers Hilton and Love from the district attorney's office to the witness list. And when I cross-examined Mr. Copeland,
Added the court to the witness list. When do you see that? The judge, the prosecution, y'all got to come testify. That's what we need.
that day comes, I'm going to ask him about how much pressure, if any, the court put on him. And you're going to be the one instructing the jury. And I just can't imagine how that's fair to Mr. Williams. So I just ask you, I'm not abandoning anything in the joint affidavit from the Honorable Attorney Adams and myself, but if you would just look at just even paragraph 12, again, if you didn't consume it entirely, I don't believe that meets a legal conclusion or a bare assertion. I ask the court to recuse.
I've read your affidavit, Mr. Steele, and I've consumed everything on it, and that doesn't change my ruling at this point in time, respectfully.
I also, on the transcript, I'd like the recordings and the transcript, and I object to the court going through it and deleting it, because to me, the way I understand it, there is zero privilege. So I don't understand how.
I'm not going to, Mr. Steele, I can't argue with you about anything such as, I've made my ruling, okay? If you have some other basis to ask for the recordings or anything like that, you're going to have to put those in some.
So disrespectful. He about to start eating and chewing and crunching while he talking to him. What kind of judge do that shit?
Other pleading, but at this point, I'm going to, Ms. Weaver's going to prepare the record. She does that, and like I said earlier, the record should be ready soon, and you all, as a defense group, will have the opportunity to take a look at that particular ex parte transcript that was done in chambers, less anything that is totally that the court considers to be privileged. And I'm going to let you do that before you examine Mr. Copeland. So you'll have everything that you have at that point in time.
Thank you.
All right. Okay. All right. Let's turn now to the statements or interviews from January.
That finishes our business today, man.
You don't want to stick around?
No.
Okay. Okay. Well, okay. Thank you, Mr. Banks. At all. Okay. All right. Okay. Yes, you may be excused, sir.
We have not heard from defense counsel yet, so I'm not sure if they've reviewed them and if they have any additions or disagreements. So we were just waiting for defense counsel to let us know their position.
Okay. Counsels for defendants, have you identified, since now the state has sent you parts from the 28th January interview that you wish to talk about? Mr. Short?
Good morning, Your Honor. I have not had a chance to digest their proposed redactions. I'm happy to talk to them about it. I've been working on getting together the redactions that we believe are warranted. Again, I'd be happy to talk.
Terroristic threats against the security guards at the mall.
Yeah, you're talking about last one.
Yes, Judge. The next one is going to be Act 60. Terroristic threats against the security guards at the mall.
Yeah, you're talking about last one.
Yes, Judge. The next one is going to be Act 60 for the indictment, which is on 3/25/16. It is a music video entitled Slime Shit, and it talks about YSL shit, killing 12 shit, 12 being a euphemism for police officers, fuck a jail shit, I'm a VIP and got a pistol on my hip. Again, and you know, I took what Mr. Lau said, and I don't disagree with him. If we have someone singing these kind of lyrics and isn't living this lifestyle before they sing about it, I don't think that's a crime. That's not the case here. We're basically singing lyrics about what they're doing. The fact that Mr. Lyles isn't aware of what his business partner is doing is the other issue. In that song it goes, again, fuck the police, fuck the judge, mob life. On 9/24/17, Act 68, I believe 69, 70, 71, and 72, Your Honor. This is an act out of Brookhaven Police Department that Mr. Steele spoke of, where Mr. Kitchens and Mr. Williams were stopped in a car based on a traffic violation, and a stolen weapon. I'm a superstar. Can't take me to jail. The officer did. I think Mr. Williams discovered there that didn't work. Your Honor, in Act 73, on 12/30/17, Mr. Williams appeared in a video. It was called Original Slime Shit, with lyrics, murder, gang shit, YSL, till you're dead and pale. Act 74 is a music video on 4/12/18, where Mr. Williams states or sings, I never killed anybody, but I got something to do with that body. That would be our position, is that as the leader of this criminal street gang, Mr. Williams probably has never killed anybody. I don't know that to be true or not, but he probably has others do it for him, as we understand the evidence, Judge.
When was that Act 74 music video?
Which one, Judge? I'm sorry.
Act 74, you said.
Act 74
The one you
was
just told us.
4/12/18, Judge.
Okay.
And again, the way as we address it in our evidence, Judge, we essentially address that as a confession by a party opponent. In Act 75, Judge, which is another traffic event in DeKalb County, a defendant in this indictment. Now let me set this up, Judge. And you heard part of this last time, that there was the theft of a car by someone in the gang, Mr. Huey, and it belonged to I believe, a manager of Mr. Williams. Mr. Williams was upset to find out that it was, and he basically texted his folks to say, give it back. Okay? Now, in that, he responds to Mr. Huey, says, if he don't take it back, he going to die. Followed that, Mr. Huey basically was begging for his life in the conversation. It's very clear that he believed that statement by Mr. Williams. That from gang members, and some on the indictment, some not, that Mr. Williams is the leader of the gang. He directs the gang activity. This gang, as you can see through the indictment, there are numerous murders, there are numerous armed robberies, there are numerous attempted murders, shootings. Just like, again, I spoke about the Gaudis, about the criminal gang, mafia families out of New York. The bosses themselves never got their hands dirty. The position here is, Judge, I spoke about the indictment. There are numerous murders, there are numerous armed robberies, there are numerous attempted murders, shootings. Just like, again, I spoke about the Gaudis, about the criminal gang, mafia families out of New York. The bosses themselves never got their hands dirty. The position
This
here
nigga
is,
said
Judge,
like the Gaudis.
Mr. Williams directs and has directed all of these individuals, Judge. And he recruits people continuously, Judge. We have a proffer, Judge, even from the mother of one of the defendants in this indictment, who told us that Mr. Williams does the community events in order to recruit more people, that her son was recruited by money, shoes, clothes, because they didn't have anything. And now her son's, by her statement, is in jail for the rest of his life. And that's that's the mother from one of the defendants on this case. Judge, Mr. Williams essentially is YSL. Everybody else is a follower. There are leaders. We said Mr. Kitchens, Mr. Greer, they are also leaders. But the Kitchens, Mr. Greer, they
So where have we seen in this whole trial that he was a leader of anything that's been happening with all these witnesses? Ain't none of them said he was leading them at all. Where he get this info from? Show me that.
are also leaders. But the leader, the top dog, the most dangerous man here is Jeffrey Williams, because he doesn't have to get his hands dirty. He has others to do his business. Judge, in an analogy, you found the others danger to the community, danger to commit additional felonies. And I would say, of the least of them, you found them dangerous. This is the most of them. This is the one that you see the shadow in the back of the room. He's the one directing traffic. He is the one they're all afraid of. He's the one that's King Slime. He's pulling the shots. He is the most dangerous of the 28, Judge. And I implore you not to grant him a bond. He is dangerous. The setup they've given to you is actually going to be less controlled, not more. If he gets a burner, Judge, and the court may know this, a lot of the communications that Mr. Williams is on FaceTime.
That's crazy. They could just sit there and just lie. They don't have no proof of what they saying. They going off somebody else's word. But since they didn't swear in, it don't mean nothing. So that's why they make you sign that paperwork that say under penalty of perjury. Ain't nothing he said under penalty of perjury. Because you know why? If it was, his ass would be in jail. Or sued, or one of the two. Anyway, let's keep it moving, family. Appreciate y'all for being here. Hit the like, hit the subscribe, tap in. We're going to keep it rolling. We got some more.
Before you sit down,
Raise your right hand. You swear in front of the testimony in court, truth, the whole truth, and nothing but the truth. Take your seat. State and spell your first and last name.
Kevin Lyles, Kevin-Liles.
Good afternoon, sir.
How you doing, Mr. Steele?
I'll let you know. Can you do me a favor and give the Samba Court, educate the Samba Court on who you are? Your background, the court may not be familiar.
Your Honor, I'm a 54-year-old father of four. I'm kind of emotional because how good this guy is. I have Morgan State University. I built a stadium in my old school. I have a street named after me. I have all kind of honorary doctorates. I employ probably 5,000 people. I was the president and CEO of Def Jam. I've been in this music called hip-hop for 38 years. And for the life of me, I don't understand why I have to testify the good that hip-hop has done around the world. I've also started a company with Jeffrey called Young Stoner Life. And I remember what he said to me. We're not just starting a company. We're going to change some lives. And that's what he's done. And he's definitely changed mine.
Mr. Lyles, how long have you known Mr. Williams?
Well, I was a fan for probably 12 years, but I personally got to know him over the last 10 years.
Okay. And have you signed, or your company signed Mr. Williams?
Yes, he signed to us. And I hate saying that he signed to us because it's my partner, but we have two deals. One deal is a deal for him as an artist, solo artist, and the other deal is for Young Stoner Life.
And I know this is personal, but financially, there's been testimony that if this trial, and I'm not saying the court would allow it, but if it doesn't take place for a year, there'd be over $1 million in expenses just for 24-hour security of police officers to ensure, off-duty police officers' second jobs to ensure Mr. Williams does not flee, does not get types of weapons, does not intimidate a witness, is not a danger to community property in the community. Can he afford, from your personal knowledge and how much money he earns, can he afford that type of undertaking?
Jeffrey can afford it, and I can afford it, so we'll be paid for it.
And you are willing to back him as well?
I'm willing to back him personally and professionally.
Okay. Please explain, if you can, and discuss fully how your life intersected with Mr. Williams' life.
My job is to seek out talented people. And I think God brought us together in a very weird way, but I think we were meant to be together. Jeffrey is not just an artist. He's an influencer. He is a person that I think was put here to change the people around him. And he's so talented. He's creative. He's innovative. And he's fearless. He's a risk taker. And those kind of people, I call them change agents. I'm not signing this artist. I'm raising a young man. He looks at me as a father figure. He's not, we can't limit it to just his lyrics or his music. He's a young man, he will be a contributing citizen to this world, and that's what I invest in. And I truly believe this whole thing that people are talking about, it's not him. The Jeffrey I know, give me clothes off his back. The Jeffrey I know, I'm giving my kids, he's giving his kids. That's the Jeffrey I know.
You mentioned lyrics. There's been a lot of argument by the prosecution about the lyrics in songs. Can you explain, if you have any insight, what is selling in the rap industry dealing with the lyrics, and why are they being promoted, and why are people wanting it?
Your Honor, you've I don't know how old you are, but I'm older than you. So, I've been fighting this battle for over 4 years. It's not new. And it's funny how we're the #1 music in the world now, and they want to bring this back up. Now, we don't argue about any other movies or other genres of music that talk about I ran them over in my truck, or I got drunk and I went and shot him. We don't bring those things to court. But quote unquote our music, we've been on trial, and we constantly on trial about who we are, what we are, why. Anybody gave us nothing. So we sit here on trial, we talk about lyrics. Lyrics. I don't understand the thing. I would be here, I'm going to keep fighting for it because I believe self-expression. And I believe we should protect black art. We should protect black art. And I'm on trial for lyrics. Come on, man.
With regards to Mr. Williams, and the court may not be familiar, where does he rank in, if there is such a ranking, in the music industry?
Objection. That's not relevant to anything.
Shows his employment status, it's part of the other factors, and whether the record company is going to continue to back him.
I think I've already established that through the witness his willingness to entry beyond alternative release.
Okay. You understand that Mr. Williams was charged in 2018 in DeKalb County with a offense involving, he was riding in a car with 2 other people, and there was a gun and a small amount of drugs in the car. Are you familiar with what I'm talking about?
Yes.
Okay. And you know that case, it's still pending, believe it or not, but it went up to the appellate court. I don't know. Are you familiar with all that?
Yes.
Everything was suppressed by the Honorable Superior Court Judge in another county, and then the state appeal got reversed, and it's pending. You're aware of that?
Yes.
Okay. So Mr. Williams is actually on bond for that case.
Okay.
The allegation also entails the fact that when Mr. Williams was arrested at the home here in Atlanta, a search warrant was then executed at that home, and there were multiple firearms. One firearm is allegedly illegal. It turned into like a machine gun, and there was supposedly about 2 pounds of marijuana and some items in, looks like an energy drink, but it supposedly contains either Schedule 2, 3, or 4 drugs in it, codeine, supposedly. Are you familiar with that?
I read it.
Okay. Understanding all those facts, the DeKalb County case, current bond, and the search of the home, you're also aware that many other people were in that house at the time of the search warrant, right?
Yes.
Okay. I'd like to ask you the following questions, in addition to the fact that we are charging 2 counts in this current indictment. You're familiar with the RICO conspiracy and the gang?
Yes.
Count. Okay. On your oath, would you be willing to back with your own personal property and wealth as well as your own company's personal property and wealth. The bond for Mr. Williams, if the Honorable Court wanted a high bond.
Objection, Your Honor. Just asking answer. The witness actually has already stated that.
Yeah, he already said he didn't put up
his.
his own and his company's resources, so I'll stand objection.
Would you be willing, okay, if it's the same question, I apologize, but I thought it's a different question. You have to understand that if the court wanted to, you would lose that wealth if Mr. Williams violated a condition of bond. And it's not just go on bond with Mr. Williams in custody or released. The court could have you signed as a co-signer on that bond, and you would actually have a lien against your wealth if Mr. Williams violated a condition of bond. Are you still willing to do that?
Like a son to me, yes, sir.
Okay, without hesitation.
Without hesitation.
All right. Do you believe that if granted bond on your oath, Mr. Williams would intimidate any witness?
No.
Obstruct the administration of justice?
No.
Be a danger to the community or property in the community?
Not at all.
And a risk to commit a crime while out on bond?
No, not at all. He has too much respect for me, and too much respect for the company that we're building, and too many people that depend on him. It's not about Jeffrey. So it's about the family, it's about the community. You know, he understands he's inspiring the world right now. There's a kid that he changes their life every day. I really believe that.
For the better?
For the better.
I have one last question for you. If the Honorable Court granted bond, but it was very, very restricted. Mr. Williams is not coming out to studios, he's not doing videos, speaking with him may be curtailed. Is your record label still willing to keep him as a vibrant member of SAM?
That's my partner.
And just for the court's edification, I think you just said, but Mr. Williams is not only an artist, he's an owner of the company, right?
He's a businessman. I told him hip-hop has given him a way to be an entrepreneur, a way to empower people, a way to educate people, and he has a responsibility. He knows that with the success comes responsibility. And we made a commitment to each other that we're going to do this for the rest of our life.
I want to thank you so much.
Thank you, man.
Hold on a second. Any questions? Okay, all right. Then I'll
I'm the gatekeeper.
We'll call, thank you so much, Mr. Corey Jackson.
What's Mr. Jackson going to testify to?
Your Honor, he is a young man.
How many witnesses do you have, Mr. Steele?
Six, Your Honor.
Okay, and what's the next witness going to testify to?
Your Honor.
You hear that? He banging on him already for 6 witnesses. And the state got like 100, 200.
He's a young man. He's just turned 15 years of age. He met Mr. Williams. Mr. Corey Jackson.
What's Mr. Jackson going to testify to?
Your Honor, he is a young man.
How many witnesses do you have, Mr. Steele?
Six, Your Honor.
Okay, and what's the next witness going to testify to?
Your Honor, he's a young man. He's just turned 15 years of age. He met Mr. Williams when he was 8 years of age. He was selling CDs in the Perimeter Mall. Mr. Williams, he was in poverty. He's from Jackson, Mississippi. His family's here as well in your courtroom. Mr. Williams explained to him that...
Hang tight. Mr. Steele, if it is your goal to establish that Mr. Williams has significant ties in the community, I believe you've established that to the court's satisfaction. Not that I don't want to hear your witnesses, but it's cumulative at this point in time. I mean, if that's the purpose of these next witnesses, unless they go to some other bond factor, you know, I'm kind of really at this point in time, I'm not really interested in hearing from him at this point.
Well, he goes more to a different factor, Your Honor.
And what's that?
Danger to the community. Good afternoon, Mr. Jackson.
Thank you. Good afternoon to you.
It's up to the court, and it's also up to you if you want to take off your mask with the Honorable Court's permission. If you want to keep it on, you absolutely keep it on.
Okay.
Your choice, man.
I'd like to take it off then.
Mr. Jackson, introduce yourself to the court. Tell the court what you do.
Well, I'm Corey Jackson. I'm a recording artist, motivational speaker, and actor.
And are you in school?
Yes, sir.
What grade are you in?
I'm in the 11th as of right now.
And you're 15 in the 11th grade?
Yes, sir.
How did you do that?
Well, I'm homeschooled, and I stay up on my studies, and I work on that.
Do you remember meeting a gentleman named Mr. Jeffrey Williams?
Most definitely, yes, sir.
Do you see him on this Honorable Court's Zoom screen?
Yes, sir.
And how did you meet Mr. Williams?
Well, the first time I ever met him was in the mall. It was in Cumberland Mall. I was probably 8 or 9 at the time. I had first met him with my music, and I approached him, and I didn't know who he was. But later on that day, after I had met him, I found out who he was as far as an artist, and I found out more about him. And then when I really met him, and we made the connection, made the bond, it was later on when I was like 10 or 11 years old at the time.
And were you in, I know it's personal, but were you in poverty at that time, if you know what I'm talking about?
Yes, sir. I understand what you mean.
And where were you living at that time?
Well, I'm from Jackson, Mississippi originally, so down there it's called Rail Street, Shady Oaks, Christian Brotherhood.
And is your father in the courtroom?
Yes, sir.
And other family members?
Yes, sir.
Okay. Tell this Honorable Court if Mr. Williams ever took you to where he was raised on Cleveland Avenue.
Yes, sir, he has.
And tell the court what you learned from that and what the...
Look at how the judge was looking at Steele, though, real quick. Hold on. Let me run it back 10 seconds. Look how he was looking at him.
purpose was.
Well, at the time, Yeah.
I know it's personal, but were you in poverty at that time, if you know what I'm talking about?
Yes, sir. I understand what you mean.
And where were you living at that time?
Well, I'm from Jackson, Mississippi originally, so down there it's called Palm Rail Street, Shady Oaks, Christian Brotherhood.
And is your father in the courtroom?
Yes, sir.
And other family members?
Yes, sir.
Okay. Tell this honorable court if Mr. Williams ever took you to where he was raised on Cleveland Avenue.
Yes, sir, he has.
And tell the court what you learned from that and what the purpose was.
Well, at the time, he took me there because I always expressed to him how at me being at such a young age and being able to achieve what I have and have the knowledge that I do have, that's why I started motivational speaking, because I want to inspire youth and show them that anything is possible. Because you can look at somebody while they're older, you say, oh, that's good, they're doing it, but now you have an example that's your age and close to your age that's showing you that it's possible. And Mr. Williams, he took me to where he was from. And he showed me where he came from, he showed me the property that he lived in, and he told me, the saying, each one teach one, which is something that he lives by, and he has also helped instill in me that I live by now, each one teach one. And he told me whatever knowledge you have to be able to spread it, because this is who you are trying to inspire and show them that they can become successful. So that's what he took me there for, and showed me how he was able to achieve what he has and where he comes from, and what I have to do if I want to motivate more young people like me.
And tell this honorable court whether you have gone across our country talking to other students, people your age and younger at schools.
Yes, sir, I have. I've did different things like different school tours and doing motivational speeches for different organizations like the Boys and Girls Club and different things of that nature, and different youth centers, detention centers, of course, schools. Yes, I have.
And has Mr. Williams put upon you the duty that you have to always be positive and try to get other people not to do crime?
Yes, sir, he has, and he has always motivated me in that goal and that mission. He's always showed me that path and always deterred me from anything that could be negative or affect me in a negative way. He always deterred me from that and showed me the right way and showed me a positive way to do anything I have going on.
Has Mr. Williams taken you on tour with him with your family's permission, taking your family?
Yes, sir, he has.
And if you can remember, what are some of the places that you went with Mr. Williams?
Atlanta, Georgia, Los Angeles, California, St. Louis, Chicago, New York. I've been to New Orleans with him before, many different places, Tampa, and some more places. It's been a lot.
Houston, Texas?
Houston, Texas, Dallas, Texas.
Okay. And have you been on stage with Mr. Williams and talking to people about all positive motivating in a positive direction?
Well, yes, sir, I have been on stage with him, and we have also made motivational videos with motivational messages.
And when you go to schools, is that with Mr. Williams' request?
Yes, sir.
And what do you tell the other children when you're there?
Well, first I speak on my 5 keys to success, which are hard work, determination, dedication, motivation, and ambition. And I show them how you can utilize, if you are utilizing these 5 keys to success, how you yourself can become successful. And that is also what he helps and he sponsors me with. And when I go through the schools, I also speak on things that aren't at this stage in life taught, because while you're in school, you're going off of your report card. But when you get out of school, you're going to go off your credit report. And that's why I also teach and speak on financial literacy.
Mr. Jackson, do you ever have conversations with Mr. Williams about your the way you are outlooked, and it has to be positive, as opposed to some people look at him with the name, quote, young thug? Does he ever explain to you not to do that?
Well, actually, we have had conversations, and he has been very vocal about not liking the image that is associated with the name Young Thug, because whenever you picture that, you assume, he's a thug, and that's why we have talked. He has discussed with me how he would like to reevaluate and reshape his image into his name, Jeffrey, and how he would like to go forth with that being his name, and that's what people associate with him, Jeffrey, instead of the image of a Young Thug.
Is it Mr. Williams' communications with you that he wishes that people do not do drugs or alcohol be a danger to the community?
Yes, sir, he has expressed that to me, and he has also expressed that to many others.
And does he use you as a lightning rod to express it to other people?
Yes, sir, he has, and he still does.
What is YSL? Are you a member of YSL?
Well, I'm not signed to the label on papers.
What is YSL to you?
Well, to me, YSL is a family. To me, YSL is, ever since I first met him, it's been all love, all respect, and it has been pure. And for me, when we spoke on it, other than, the name of the label,
I muted the wrong one. But now he found something to write down, right? That the youth is a member of YSL. You think he wrote something positive, or did he say it's affecting the youth in a negative way? I'm going to run it back.
Stone like rappers. And he has also expressed that to many others.
And does he use you as a lightning rod to express it to other people?
Yes, sir, he has, and he still does.
What is YSL? Are you a member of YSL?
Well, I'm not signed to the label on papers.
What is YSL to you?
Well, to me, YSL is a family. To me, YSL is, ever since I first met him, it's been all love, all respect, and it has been pure. And for me, when we spoke on it, other than, the name of the label, Young Stoner Like Rappers, I told him my YSL means Young Successful Life, because that's something that he has created. He is a young successful man himself, but also he is helping more young men and young women have successful lives, such as myself, for example. And that's why my YSL stands for Young Successful Lives, because that is what he has done, and that is what he is now creating and showing and putting into the community.
Sir, has Mr. Williams' tutoring and guidance to you taken you out of poverty and your family?
Yes, sir, it has.
Has Mr. Williams ever asked you for a nickel?
No, sir, he has never asked for no profit or proceeds from anything that he has helped contribute with, never.
Your Honor, with the court's permission, Ms. Edwards has a very short video that relates to Mr. Jackson.
Okay, he's testified here, so it's kind of like so.
It'll explain background.
I don't see the dangerousness in this, Mr. Steele. He buttresses again what I indicated earlier, which is he has significant ties. He's helped a number of people in the community. But I don't see the danger of the community that you promised me from the testimony.
He's the opposite. I think that my promise is good. Mr. Jackson is saying that the entirety of Mr. Williams' desires is that people do not commit crime, do drugs, do violence, and to stay in school. That pinpoints the whole James community is risk of crime, risk of committing crime. He's Mr. Williams through, along with Mr. Jackson, diametrically opposed.
Okay, all right. This video, you want to show me how long is it?
2 minutes.
And what's it going to show me?
It'll show you Mr. Jackson on The Ellen Show. It'll show him on CNN. It'll show him interacting with Mr. Williams, interacting at schools, just to give you an idea of how this message is all across the
I think
country.
he's testified that more than significantly. I mean, I'll accept the video as proof of that, further proof of that particular issue, but I think Mr. Jackson here has well articulated that issue.
Okay. Then I have no other questions for Mr. I want to thank you so much for being here.
Thank you, sir, and thank you, Your Honor, for allowing me the time to come and speak.
Oh, you're very welcome, young man. Any questions, Mr. Geary? No, sir. All right, young man, you can step down and see.
I'm the gatekeeper.
What y'all think about that, family? Y'all let me know. I had some things I wanted to say, but I'm going to hold off for that right now. But y'all see it. Let's go.
All right, folks, before I go ahead and get started, whatever the decision is today, this is a forum, a public forum, which all are welcome. However, if you feel that you cannot govern your behavior or have acceptable conduct, please, you can exit the courtroom and nobody will be the wiser. If you make any outbursts or statements or anything that the law enforcement professionals in this courtroom deem to be inappropriate, you will be removed from the courtroom and maybe subject to other action. So I just tell you that up front because my deputies are charged with the responsibility of good order and discipline. So whatever my decision is, like it or not, I'll give you an explanation for it, but outbursts were not acceptable, okay? All right. So with that, counsel, I've gone ahead and based upon what has been proffered and the appellate the case law should say has been provided to the court. I'll summarize a couple of different things already that you as counsel for the state as well as for the defense, I'm sure aware of. I'm looking at Coleman versus the state, and that's already been cited. That's 361 Georgia Appeals 901, and I'll quote from that decision, which is which comes from our court of appeals. Judge Miller, Beth Miller, being presiding judge in that particular case. Excessive bail is prohibited by the Georgia Constitution, Article 1, Section 1, Paragraph 17, and the 8th Amendment to the United States Constitution. And for the 8th Amendment analysis, as you all are aware, that 8th Amendment violation would be excessive bail or no bail, or fixing an amount that is excessive under the circumstances. When fixing, for the purposes of the 8th Amendment, the excessive bail is defined as bail set at an amount higher than the amount reasonably calculated to ensure the presence of the defendant. When fixing bail in Georgia, trial judge's foremost consideration is the probability the accused, if freed, will appear at trial. And then the court in Coleman goes on to quote that lesser factors or lesser extent or considerations are the accused's ability to pay, the seriousness of the offense, the accused's character and reputation. I've heard a lot of evidence today about those particular factors in regards to Mr. Williams and his ability to pay and the seriousness of the offenses and his character and reputation from represented by Mr. Steele, Ms. Hornsby, as well as Mr. Adams. So I have considered those particular issues. Now, also, Coleman goes on to say that a defendant who seeks release on bail has the burden of showing roots in the community. The defendant does not pose a significant risk of fleeing, threatening the community, committing another crime, or intimidating witnesses. And along with this particular case, the court also has considered the seminal case of Ayala versus the state at 262 Georgia 704. And Ayala gives us the framework in Georgia for the purpose of a pretrial bond is to prevent punishment before conviction and secure the appearance of a person for trial, quoting Roberts versus the state, 32 Georgia Appeals 339. And it goes on to say that a trial court may release a person on bail if the court finds the following. So I have to look at the first thing that Coleman directs me to look at is consideration of whether or not the foremost consideration is will he, if free, appear at trial, and then the lesser factors, and these are: a court may release a person on bail if the court finds 1, poses no significant risk of fleeing from the jurisdiction or failing to appear in the court when required; 2, poses no significant threat or danger to any person, to the community, or property in the community; 3, poses no significant risk of committing any felony pending trial; and poses no significant risk of intimidating witnesses or otherwise obstructing the administration of justice. And I'm required to explain any reasons if I deny bond to assist the appellate court in its review, and that the granting or denial of bond will not be set aside unless there's a manifest and flagrant abuse of discretion. That's Jernigan versus the state, 111 Georgia 307, pinpoint 308, very old case from 1903. Now, In regards to considering bond for Mr. Williams, I have considered the first consideration is if free will he appear at trial, and to a lesser extent the other factors. And based upon the court's consideration of the proffer, the two things that the court has significant concerns about are him being a danger to the community and flight. And I'll state for the purposes of the record and purposes of my decision that I realize that Mr. Williams is presumed innocent. I realize that he has the presumption of innocence stays with him until the state, by sufficient evidence, is able to prove to a jury's satisfaction beyond reasonable doubt, I should say, that he is guilty of the offense or offenses charged. But however, in this particular circumstance, there have been significant proffers about Mr. Williams as being a danger to the community. In particular, the state's proffer that they have taken proffers from other gang members and people who are in this particular indictment and they're not in this indictment, that he is the leader of the gang, he is dangerous, and if he crosses them, he'll kill them or their families. And the predicate or the review of the state, the concerns that I have are some of the statements that he's made about the threats and to others, and that have been chronicled in particular in some of the predicate acts that have been stated for the court's consideration. Whether or not those acts, as Mr. Adams has pointed out, because they have to be proven at trial, is a discussion for another day. But at this point in time, in the aggregate, those particular discussions, in particular, the proffer from the people that the state has talked to already, the group chat that from 2015 starting, anybody goes in the courtroom and tells God honest truth, they'll be fucking killed, pardon me for the language, and this threat is still being talked about. So that is of a concern to the court in regards to the danger to or threats to persons in the community. So and factors, there's no significant arrest, intimidate witnesses, or otherwise obstructing the administration of justice. That is the court's concern. The two major concerns that this court has is danger to persons and threats to intimidate other witnesses and obstruct the administration of justice. So I have some concerns about the flight that I share with Judge Wolf also indicated, but and I'm not going to hold it against him that he is very successful and has significant means. But those two factors in particular, threats to persons in the community or pose a significant risk of intimidation of witnesses, otherwise obstructing the administration of justice, the court has considered a number of the predicate statements, and for those reasons in the aggregate, I'm going to deny bond at this time. But Mr. Adams, Ms. Hornsby, and Mr. Steele, certainly if you should file any other additional motions or things that will change, I certainly will reconsider the court's position on bond. It is not lost on me that I have not given your client a bond, but that is my decision based upon what I've heard, and I certainly appreciate your advocacy on behalf of your client, all of the lawyers thus far who have advocated very well for their clients in this particular position. And I will do my level best to make sure that this case gets tried as expeditiously as possible, and if I can get it on the calendar before the 9th of January, I will endeavor to do so. So, anything else at this point in time?
One thing, Judge.
Yes.
And so I know the court filed, I sent an email to, I think, the Public Defender's Office concerning getting defendants who are presently unrepresented representation. We wanted to kind of weigh in on that. We filed a motion today requesting the court to respectfully get them so we can get everybody arraigned and get it moved. I want to just get
brought over as soon as possible. But and if you all have information in regards to that, please let us know. But we're tracking that issue, and I will continue to talk and dialogue with Mr. Chamberlain about that. Okay.
Yo, shout out to Julie for bringing that back to me. You know what I'm saying? She hit me with a couple emails or some stuff, and I seen it all before, but it's so much stuff you get lost, and I had to go back in there and dig that back up because it shows how he been biased from the beginning. Judge bias being biased. Anyway, let's keep it moving, family. Appreciate y'all for being here. Like, comment, subscribe, tap in. Let's keep it going.
haven't seen one person who I'm like.
A record in the matter of the state of Georgia versus Antonio Sledge in 22 SC 183572. Good afternoon, Mr. Wright.
Good afternoon, Judge.
Good afternoon, Mr. Sledge.
Good afternoon, Your Honor.
And good afternoon, counsels Love and Hilton.
Mr. Sledge, please state your true, correct, and legal name.
Antonio Sledge.
And are you the same Antonio Sledge, also known as Milton, who is listed in indictment 22 SC 183572?
Yes, ma'am.
Are you at this time taking or under the influence of any alcohol, drugs, or medication?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No, ma'am.
How old are you, and how far have you gone in school?
I'm 4.
So I threw this in real quick to show you the bonds that did get granted. He got granted, and remember Woody and Tick and all them, they out on bond, right? But not Young Thug, huh?
21, 10th grade.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you are charged with the following offenses?
Yes, ma'am.
Conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act,
Yes, ma'am.
as well as possession of a firearm by a convicted felon,
Yes,
as
ma'am.
listed in count 30 of this indictment.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges, and that if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
Have you had enough time to speak with your attorney, Mr. Derek Wright, about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with his services?
Yes, ma'am.
Do you waive a formal reading of the indictment?
Yes, ma'am.
Do you waive any and all defects in the indictment, including any with respect to your name?
Yes, ma'am.
Have you been arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Do you, Mr. Wright, know of any outstanding warrants that are related to these charges?
I do not.
Mr. Sledge, has your attorney advised you of the minimum and maximum sentence for each charge that you are pleading guilty to
Yes,
today?
ma'am. Yes, ma'am.
Do you understand that the minimum sentence for conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act is 5 years and the maximum is 20 years in prison?
Yes, ma'am.
Do you understand that the sentence for violation of count 30 of this indictment, possession of a firearm by a convicted felon, as in OCGA 1611-133, is 15 years in prison?
Yes, ma'am.
Do you understand that this is a negotiated plea of guilty,
Yes, ma'am.
which means that the state will recommend to the court the following sentence?
Yes, ma'am.
As to count 1, 15 years to serve on probation, subject to the special conditions contained in the plea agreement that I have in my hand that I will show you in just a moment. And on count 30, although you are pleading guilty, sentencing will be withheld until the completion of the initial trial of this case. After the initial trial of this case, provided defendant you have complied with the special conditions outlined in sections B, C, D, F, and I of section 3 special conditions of sentence of this plea agreement, the state agrees that the defendant shall be allowed to withdraw his guilty plea on count 30, and the state shall agree to null pros count 30. Do you understand that the court does not have to accept that recommendation? And we will read into the record the terms of the plea agreement in a moment. Do you understand that?
Yes, ma'am.
Do you understand that the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other if the court does not accept that negotiated plea?
Yes, ma'am.
Okay, another note. Do he say anything else besides yes, ma'am throughout this whole video? He even say yes, ma'am before she done with the question.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today, but that the state is not recommending either?
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including in the federal courts?
Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that this plea involves your being placed on probation, and that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special condition of probation without being subject to revocation for the balance of the sentence? Do you understand that?
Yes, ma'am.
Do you understand that you are not allowed to use or possess a firearm while on probation?
Yes, ma'am.
Do you understand that if you are not a United States citizen, a guilty plea will affect your immigration status and will result in deportation, just like a conviction at trial would, and that this is true regardless of any advice given to you by your attorney or anyone else?
Yes, ma'am.
Do you understand that if at any time you are sentenced to confinement based on this sentence, neither the court, your attorney, nor the district attorney's office has anything to do with parole, and that in that circumstance, the Department of Corrections or Board of Pardons and Paroles
Yes, ma'am.
are the only persons who can address parole, and that no one can guarantee parole no matter what anyone has told you?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, your right to receive, possess, or transport a firearm, and your right or ability to obtain employment. Do you understand that these rights may be affected?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of another felony, which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that if you went to trial, you would have the right to try by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Do you understand that you are giving up all of these rights?
Yes, ma'am.
I'm showing you what has been marked as State's Exhibit 1AS. Do you recognize the document in State's Exhibit 1AS?
Yes, ma'am.
And is that your signature on page 7 of 7 of State's Exhibit 1AS?
Yes, ma'am.
Your Honor, at this time, actually, and Mr. Sledge, have you had an opportunity to review each and every provision within State's Exhibit 1AS?
Yes, ma'am.
As reflected on State's Exhibit 1AS, the current charges that you face are count 1, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, and count 30, possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm, OCGA 16-11-133. The negotiated sentence, as outlined in State's 1AS, is count 1, 15 years on probation, and count 30, sentencing withheld until the completion of the initial trial of this case. After the initial trial of this case, provided defendant has complied with the special conditions outlined in Section B as in boy, C as in Charlie, D as in Delta, F as in Frank, I as in Indigo of Section 3 special conditions of sentence of this plea agreement, the State agrees that defendant shall be allowed to withdraw his guilty plea on count 30, and the State shall agree to null pros count 30. The special conditions of the sentence, as outlined in Section 3, are that defendant shall abide in full by each and all of the terms of this negotiated agreement. Defendant's failure to abide by any term of this agreement shall constitute a violation.
So what they saying is, as long as he follow all they bullshit, then they'll drop the guilty charge, or as long as they win in court, pretty much. They saying they'll drop the guilty charge at the end of the trial. Ain't that some shit? At the end of the first trial, at the end of the Young Thug trial. If they win, then they'll drop his guilty plea. If not, they're going to keep his ass in jail and deport him.
Of the agreement. Defendant shall testify truthfully about all matters relating to this case upon which he is questioned at any trial or judicial proceeding stemming from the facts alleged in this indictment. In accordance with testifying truthfully about all matters relating to this case, defendant acknowledges that each and all of the statements contained within the defendant's factual acknowledgments section of this agreement are true. Defendant shall testify truthfully about each statement contained within defendant's factual acknowledgments and any matters related to this case when asked to do so in any proceeding related to the facts alleged in this indictment. Defendant shall possess no guns unless his right to do so is restored. Defendant shall commit no criminal acts. Defendant shall submit to random drug screenings by the Department of Community Supervision and any agency designated by the court in this case. Should the defendant test positive for any Schedule 1, 2, or 3 drug, defendant shall within 30 days of said positive test undergo drug rehabilitation as designated by the court or the Department of Community Supervision and shall successfully complete said rehabilitation program. Defendant relinquishes any Fifth Amendment right related to any statement contained within defendant's factual acknowledgments contained within this plea agreement. Section 4, defendant's factual acknowledgments. Have you initialed each and all of the defendant's factual acknowledgments contained within Section 4 of this document?
Yes, ma'am.
And is that initial AS your initial?
Yes, ma'am.
The factual acknowledgments are as follows. Number 1, Young Slime Life, aka YSL, is an organization made up of 3 or more members or associates who share common identifiers that include, but are not limited to, colors, hand signals, and terminology, who have committed crimes intended to increase the notoriety, street credibility, and reputation of YSL. Number 2, defendant has been a member and or associate of YSL since 2012. Number 3, while associated with YSL and to support and express loyalty to YSL, defendant and co-defendant Demikion Garlington and Quindarius Zachary appeared in a video with another person, AS, where defendant brandished a weapon used in a drive-by shooting, and where on behalf of YSL, defendant threatened to harm a person named Kel, a rival gang member who had begun a relationship with defendant's ex-girlfriend. Number 4, on or about April 28, 2015, as reflected in Fulton County Indictment 15SC 138994, defendant and fellow YSL associates Demikion Garlington and Quindarius Zachary committed a drive-by shooting using the firearm defendant wielded in the video referenced in Part 3 of this section, targeting family members of a rival gang. Number 5, defendant and his fellow YSL associates committed the drive-by shooting referenced in Sections 3 and 4 above on behalf of YSL and to increase the notoriety, reputation, and fear of YSL. Number 6, defendant admitted committing and was convicted of aggravated assault and participation in criminal street gang activity, among other charges, for his participation in the drive-by shooting referenced in Sections 3, 4, and 5 above. Number 7, defendant was told by another YSL associate that immediately after the murder of Donovan Thomas Jr., YSL associates met at the McDonald's on Cleveland Avenue in Atlanta, Georgia, to discuss the murder. Number 8, defendant personally knows that one or more YSL associates committed the murder of Donovan Thomas Jr. on behalf of YSL. Number 9, on January the 10th, 2015, after the murder of Donovan Thomas Jr., defendant and other YSL associates gathered at the home of Jeffrey Williams, aka Young Thug, who gave defendant and other YSL associates cash money to lay low. Number 10, defendant has personal knowledge that on January 10th, 2015, after the murder of Donovan Thomas Jr., YSL associates traveled to Miami, Florida with co-defendant and YSL founder Jeffrey Williams, aka Young Thug. Number 11, defendant did not murder Donovan Thomas Jr. and was not a party to the crime. Number 12, defendant did not murder Shamel Drinks and was not a party to the crime. Number 13, defendant cannot truthfully assert that the persons charged in this indictment with the murder of Donovan Thomas.
Y'all catch that, right? Shamel Drakes. So they got a whole nother murder coming in that they ain't even got to yet. this is a witness coming up later to testify against Thug about a whole nother murder.
Thomas Jr. are not guilty of the murder, and defendant will make no attempt at trial, prior to trial, or after trial to exonerate the persons charged in this indictment with the murder of Donovan Thomas Jr. Number 14, the gas station at 151 Cleveland Avenue, Atlanta, Georgia is one of multiple locations where YSL associates sell drugs and do not allow other gangs to operate. Number 15, the gas station at 221 Cleveland Avenue, Atlanta, Georgia is another location where YSL associates sell drugs and do not permit other gangs to operate. Number 16, the defendant has personal knowledge that he and other members or associates of YSL have either participated in or directly committed at least one of the following crimes in order to increase the notoriety and reputation of YSL: murder, armed robbery, aggravated assault, attempted murder, theft, illegal gun possession, and illegal drug possession and sales. Mr. Sledge, have you had an opportunity to go over each one of the defendant's factual acknowledgments and make corrections where necessary?
Yes.
And do you now acknowledge under oath that each of the factual acknowledgments that you have initialed in this section are true and correct and accurate to the best of your ability?
Yes, ma'am.
Part 5 of this plea agreement, Your Honor, states that defendant's sentencing acknowledgments are as follows. Defendant understands fully that if he violates any provision or any special condition of this plea agreement, the district attorney can and will use the contents of this document and agreement during any judicial proceeding. The defendant understands fully that if he violates any provision or any special condition of this plea agreement, his probation for this sentence may be revoked in its entirety, and the district attorney will recommend that defendant serve any remaining portion of this sentence in confinement at the Georgia Department of Corrections or prison. Number 3, defendant understands fully that any violation of any provision or of any special condition of this plea agreement shall result in defendant being
Yo, some of y'all asked me to slow it down, but a lot of people already seen this and it's kind of old, so I just want to speed through it. But if it's going too fast for you, it's a settings button. Just hit your settings and you can click slow down yourself. Just drop down the speed yourself and it'll slow it down for you. Appreciate it though. Tap in, family. Let's keep going.
sentenced on count 30 of this indictment, and the district attorney will recommend that the defendant serve the maximum sentence allowed by law. Number 4, defendant understands fully that if prior to the conclusion of the initial trial of this case, defendant fails or refuses to testify to any fact that he acknowledges in this plea agreement, such failure or refusal nullifies any promise made by the district attorney to null pros count 30 of this indictment. Number 5, defendant understands fully that defendant's violation of any provision or of any special condition of this plea agreement prior to the conclusion of the initial trial of this case shall nullify any promise made by the district attorney to null pros count 30 of this indictment and may result in defendant being, and Your Honor, there is a typo that is in this document. It's the word should be being, and it's spelled B-E-G-I-N. I'm going to ask that defendant just strike through and initial that word B-E-G-I-N to B-E-I-N-G.
There's a typo. For those who asking, we reviewing what happened with the bond hearings with Young Thug, how he got denied bond, but all these other people getting bond. And then we gonna go to what's her name, Miss Bumpus. I got a live interview with Miss Bumpus, not from me, but a live interview she did talking about the case. I'm gonna play that next, so stay tuned, family. Let's go. Hit that like, hit that subscribe, tap in.
And Mr. Sledge, is that your initial above the strike through of the word began to change it to being?
Yes, ma'am.
Okay. And may result in defendant being sentenced to serve as much as 35 years of confinement in the Georgia Department of Corrections or prison. Number 6, defendant understands fully that no promises, agreements, or conditions have been made other than those set forth in this document. Mr. Sledge, are these your initials on each section under defendant's sentencing acknowledgments?
Yes, ma'am.
Mr. Sledge, do you agree that the following statement is one that you have read, fully understood, and signed your name acknowledging? I, Antonio Sledge, have read and carefully reviewed this agreement. I have reviewed and corrected where necessary for accuracy each statement contained in defendant's factual acknowledgments, and I acknowledge the truth and accuracy of each and every statement listed therein. I fully understand this agreement, and I've had an opportunity to discuss this agreement and each of its provisions with my attorney, Mr. Derek Wright. No promises other than those contained in this document have been made to me in furtherance of this agreement. I freely, knowingly, and voluntarily enter into this agreement without force, threat, or coercion. Is that the statement that you acknowledged in this agreement?
Yeah, ma'am.
And is that the statement to which you sign your name underneath?
Yes, ma'am.
Your Honor, the state tenders as evidence, and the organization of which Mr. Thomas was a member began to occur. One of the retaliatory shootings is the one that is listed in defendant's factual acknowledgments in State's Exhibit 1AS. Your Honor, as recently as earlier this year, the murder of yet another person whom the organization considered a rival, Mr. Shamel Drinks, took place, turning 2022 into sort of a repeat of 2015. That is all that I have, Judge. Again, we just asked that the court sentence the defendant to 15 years of probation on count 1. As to count 2, we would ask that the court withhold sentencing until after the completion of the initial trial of this case, and after the initial trial of this case, provided that the defendant has complied with special conditions.
Why she move out the mic to say that, huh? I'm gonna run it back a little bit. What she's saying is what I said earlier is, as long as they win this case, then they're gonna drop the guilty charge for count 30. But if they don't, then they could re-deal with it later.
Outlined and contained in the 15. That is all that I have, Judge. Again, we just asked that the court sentence the defendant to 15 years of probation on count 1. As to count 2, we would ask that the court withhold sentencing until after the completion of the initial trial of this case, and after the initial trial of this case, provided that the defendant has complied with special conditions outlined.
Shout out to Reggie Righteous. I see you in the building.
The defendant shall be allowed to withdraw that guilty plea on count 30, and the state shall agree and will agree to no loss on count 30. Now, further.
Mr. Wagner is on as well. Mr. Wagner is already. He's going to release him.
Your Honor, he have closed that once you get the time.
Yeah.
Judge, the case that was referenced that he pled guilty to before for the ag assault is closed, so he's not currently under an active sentence.
The issue is going to be is that he's got no sentence on that particular count 30. So I'm not going to have to give the bond. I'm not going to give the sentencing on count 30.
Initially, when he was arrested for count 30, he was given a $31,000 bond that he made. So
that bond still remains?
That bond is still in effect for that, I guess, underlying charge.
The state has no objection to the court granting a signature bond as to that count, subject to any restrictions that the court feels necessary to place on the defendant, and considering the fact that the defendant has now pled guilty to that charge. Pled guilty to place on the subject to any restrictions that the court feels necessary to place on the defendant, and considering the fact that the defendant has now pled guilty to that charge.
Yo, they don't give a fuck. They like, we violating. We gonna do it in front of everybody, in front of the whole world. We make our own rules, our own laws, and I just deal with it on appeal. Cause they can't do nothing to me anyway. That's crazy. All right, we're gonna keep it going. Like I said, I got an interview with Miss Bumpus. I'm gonna show that right now.
I haven't seen one person who I'm like, who they know, like not one person has said what actually happened.
Oh, really? Oh, okay.
Really?
Okay. Wow. Well, this is gonna be interesting then.
It's gonna be interesting, but I mean, I don't think the 25th is gonna happen.
He shouldn't even get in the first place. And this, I know this is not you saying this, so you don't got to doubt my statements, but it seemed to me that when you were first trying to get off the case, he didn't want to let you go because he already had in his mind that he was trying to keep you there for this show cause hearing.
So he was trying to punish me.
Yeah, that's what it was. That's what it was. Yeah. I mean, to be clear, that's exactly what it was. He didn't want to let you go. And then when the other lawyer stepped in and said, "Hey, Judge, you got the rules wrong as usual," and that's me saying it, not you. He was like, "Well, you can go." But then he handed you a paper. I already knew he was on some. Yeah, I'm gonna keep it clean while you were there because I don't want them to say, you're saying what I'm saying. But yeah, that was that. But
just point blank, period. Like I'm gonna say this is that Woody, like me, the agreement was always that I was only representing him while he was in custody. Once they agreed to let him out of custody, so I mean the whole fire was because he was trying to help me get off the case. I mean, even he knew that the judge was wrong. Like,
see, that was my first theory because a lot of times when we work with clients, we can talk to them on the side.
Close. Like I represented him a lot. Like I know him.
Okay.
So there's no bad blood at all.
Oh, okay.
It was just like everybody. No, even he couldn't believe what was happening.
Oh, okay. The way his demeanor is, and he, dramatic.
That's why he said she fired. She fired, and the judge still tried to keep her ass in there.
With it, she fired. Yeah, right. Mm-hmm. Yeah. And I was thinking, I was like, okay, if it was my client, and I tell my client, hey, the judge is not gonna let me off unless you get on board. Mm-hmm. And a lot of times, I mean, I've never had a client to just say, if they know what I want to do, they'll be like, oh, okay, so is this what I got to do? I'm like, yeah, that's what you got to do. And then we go do it.
But that was always the understanding. It was no, I didn't do anything, like all these theories about it. There was no anything like that.
Oh, okay. I was thinking that you were like a substitute attorney, even if that's the proper term. I know you.
I mean, the thing about it is me and Melnick are friends, and he knew I had previously had a relationship with Woody. So when he asked me, it was no problem because I had previously represented him. It is what it is. So what, it didn't matter. I mean, their agreement was once he was out of once he purged himself by testifying that he would no longer need representation.
Right. Okay. So, and I guess that makes sense. I mean, as far as, I was thinking that when you came in for Melnick, you were there for Melnick during the entire time, because from my understanding, he was given use immunity. And as we know, use immunity covers, what you say on the stand. They can't use that against you, but it's not full immunity. So I was thinking, does he need a lawyer there outside of, because he might say something on the stand that, that has him locked up. So that was my concern for him. He needed an attorney there. But if you and Melnick had an understanding that, hey, I'm only here until he purges his contempt, and once his contempt was purged, I'm gone. And that makes sense, because I don't think you should have been locked into that case while Melnick was gone for, week, 2 weeks. That ain't right.
Right.
You see what you were doing a favor.
Doing a no good deed.
Right? You was doing a favor and almost got trapped. They didn't want to let you go. Yeah, but
I just say this everything happened for a reason, and it happened the way it was supposed to happen.
Right. I agree. I mean, I think you did the best you could with what you had to work with. And like you said, we don't know. We're speculating what happened in that meeting. And from my understanding, in the motion, you were present in the meeting, so we don't know what was said. We don't know who came to who defense, or were you representing Woody, or were you not? It's so many questions that we want to know.
And I'm going to answer all of them, but I will say this: it was 14 people in the room. 14.
Okay. And the judge tried to say attorney-client. How do you have attorney-client privilege when it's 14 people in the room? There's no confidence in that whatsoever. But that's me. But thank you so much.
All right, no problem.
Hopefully we get you back one day.
Okay.
All right, thanks, bye.
Now it's all of a sudden another reason. Your Honor, you have ruled. I use your ruling. I embrace it, and I am correct. There has to be a point that we have traction here too. It is a two-way street.
But remember, Mr. Steele, I can always, one of the things about being a trial judge is you can reverse your rulings. And also, here's the other thing as well.
It's interesting that you're saying that you were prescribed these medications in Georgia. You can carry them without the bottle, which is interesting. So was this a misunderstanding?
I mean, you'd have to ask maybe the district attorney's office and the sheriff's department, because.
So I'm sure a lot of y'all know, but for those who don't, this is one of the lawyers who was part of the case earlier, but they got their case severed, and they locked him up for his own prescription pills. That's why they ended up severing the case, because it was about to make him look worse. Let's tap in. Appreciate y'all being here. Hit the like, hit the subscribe, share, comment. Much love, family.
I don't see how it could be a misunderstanding. The law is so clear. So had law enforcement had any basic knowledge of the law, they would have known right away that I wasn't violating anything. And further, they didn't even bother to wait for me to try to explain. They didn't call my doctors. They didn't allow me to have it tested or anything like that. And they just jumped to conclusions. And even worse, they charged me with a felony. So I'm getting a little taste of what I see day in and day out with my clients, of just these trumped up charges, these overcharged cases. So they took it even one step further. Not only did they wrongfully try to accuse me of having pills not in the original container, which is not a crime in Georgia, they accused me of violating a controlled substance statute just because a couple of the pills of one bottle were a different dose than what the bottle says. And that was only because, as often happens, my doctor changed the dose a couple months ago, and then I left a couple of the old dosage in there, but they're the same medication and they're only off by 5 milligrams. And because the pills are a different color, they try to say that, well, that's a controlled substance and that's illegal for you to even have that at all. And because the pill bottle says 15 milligrams, that you had a 10 milligram one of the same type, and because it's a controlled substance, then you're now in violation of the Controlled Substance Act, which is a felony. Pretty serious, but I'm not afraid. I have a great attorney, Mr. Brian Tevis, and I'm innocent, didn't do anything wrong. It's so obvious. So I'm not worried, but it's just an example of what they do to people. So to your question, that'd be something like in court that I'm sure you know is like speculation. How am I to get in their head and ask myself, why did they do this? But I can look at the circumstances and say that I don't think they're ignorant of it. I think maybe they knew what they were doing, or I don't know. So I don't know how they organize their things. I don't know how they make charging decisions, but that's what happened. And so I guess I can leave it to your audience based on the circumstances to also speculate about why they did that, especially in the context of everything going on this week and the bond hearing and the things that I said in that bond hearing.
Now, there was a simple battery charge that you had faced, but that charge was later dismissed. You were accused of, I guess, doing something with a sheriff's deputy, brushing up against him. Tell us a little bit about that.
So yeah, that's just more of the same. So they've already done this unlawful detention on me. They're already accusing me of something I didn't do without any investigation. And I'm in handcuffs completely. I turn around, I let them put the handcuffs on me. I don't resist at all. And then a colleague of mine says, throw me your phone. And I did want him to throw him my phone, not because I have anything there to hide, but that is my attorney phone that have sensitive information about my clients, their medical information. They had already violated my medical rights and privacy. So who knows what they're going to do? There's confidential stuff in that phone they're not allowed to see, but that wasn't my main concern. My main concern was I knew that everybody would be talking about me going to jail. I knew that people such as yourself would talk about it and that my clients would see that. And they did. Some of my clients are very concerned. They're concerned for their own case, obviously, and their advocacy, but I have pretty close relationships with my clients, so they're also just worried for me in general. And had someone not had my phone while I was in jail, I couldn't continue my business and communicate with my clients because I don't have anywhere else where their numbers are stored. And now my phone is getting all these texts about, are you okay? Is my case still okay? Are we still good for court in a couple weeks? And then especially why I'm afraid is because the Fulton County Jail is really disorganized right now and really backlogged. If it wasn't for my attorney, Mr. Tevis, I don't know when I would have really gotten out. I recently had a client who was detained unlawfully. She's pregnant. She's 7 months pregnant. There's a suspended license case that she resolved in traffic court, but because the state didn't take the warrant out of the system, she's pulled over during a traffic stop, and they think she missed court, even though she didn't miss court because there was no court to miss. The case was resolved, and she spent about 4 days in there. And that's when the family got me involved and said, what's going on? So I worried about a nightmare scenario like that. So for even a day to go by without me communicating with my clients would be a catastrophe. And so I tossed my phone to my colleague, and because I tossed it while my hands were tied behind my back, because I got the phone out of my pocket with one of my handcuffed hands, it touches on the bulletproof vest of one of the captains, and it was wild. I could tell they were just like sharks circling me. They just couldn't wait. It was crazy. The only way I can really describe it is like a bunch of children when a piñata bursts and the candy falls down. When they saw that phone just brush and touch on the deputy, the captain, they got so excited and they're like, battery on officer. And and I started getting that strange energy that you get from police that commit violent misconduct, where they say things like stop resisting while they're just punching someone in the head who's tied up and not moving. So I was just getting that energy. And so that's what it was. And then they tried to charge me with that, and it was actually so ridiculous that they ended up dropping that, and instead they charged me with willful obstruction of an officer for that. But that's also wrong. So they're funny. They try to fix it and they're wrong again. And because the detention was unlawful, you actually are allowed to resist, which I didn't. So even if I did do something they were saying I do, it would be a not guilty under the statute. So it's just on its face a not guilty across the board, even though I was charged with 4 counts, one of them being a felony.
So they locked him up for crimes that's not even illegal. Tried to hit him with 4 charges in the courtroom. And then all that shit gonna get threw out because it wasn't nothing illegal he was doing. And why would they do that? Because he was causing too much ruckus in the courtroom too early, and they couldn't have that. All the ones that was causing ruckus early got severed.
That was dropped. Anastasios, Judge Earl Glanville is presiding over this trial, and there are things he's doing in this case that I don't think I've ever seen. Assigning people essays, whether they're prospective jurors, even attorneys, assigning them essays to write, 20, 30-page essays if they are held in contempt. Very unusual. I heard that you were ordered to buy everybody lunch. What are your thoughts on all of this?
Yes, that's correct. I haven't been a part of that before either. I've been practicing law since 2015, and I've been practicing under supervision since 2012, and I've never seen that before. And the statute in Georgia for contempt gives the judge the options of a $1,000 fine, a 20-day in jail sentence, or some mix of both. So you could be fined up to $1,000, in jail for 20 days, or both. But in this case, he's assigning other consequences for contempt. And I don't believe that I even was contemptuous in that moment, but me and the judge just had a difference of interpretation over what him and I had said to each other. Even though Mr. Farley severed, I do plan to still, honor the judge's wishes.
Interesting. Rodalius Ryan is the one who had the alleged 2 bags of marijuana sewn into his boxers, not your client. But your client is facing a murder charge. He will now have a separate trial. Your thoughts on having the case severed, obviously, because he's not going to be tried.
Did y'all see that picture they showed? That wasn't even him. I got that video too of the whole arrest. If y'all want to see that, let me know. Of when he got arrested and they went in the back room. I don't know if y'all remember that, but I got it. We could tap in if y'all want to see it.
With all of these other defendants, which will take, it feels like this trial is never going to end. We're still in jury selection.
That's right. I mean, for Mr. Miles Farley, we were facing, a long fight that we knew we're going to win, but we didn't know when. I mean, we don't even know what part of jury selection we're in because we haven't started the individual questioning. We don't know how many strikes we're going to be given. We don't know how many alternates the judge is going to give each side. We don't know how the prospective jurors are going to react to the individual questioning by all 14 of the defense teams, now 13 with Mr. Farley's severance. So, that was strange. And in a strange way for Mr. Miles Farley, it's a situation where people say things, like, God works mysterious ways, because I wanted a severance from the beginning because that's the only way for Mr. Farley to have a fair trial if his trial ends up being fair. But I don't think being tried with so many people at once and so many attorneys at once and under the RICO statute in general, I don't think someone can get a fair trial like that. I mean, we're still going to win with 2 hands, tied behind our back by the RICO and the lack of severance, but I know there's so many things that are unfair about it. And so I'm actually glad that he got severed, and I'm glad that he got a bond, because now he doesn't have to be unnecessarily confined and punished just to have a fair trial, which is going to have to be after whenever this trial ends.
All right, guys. So we are picking it up here. It says this court's show cause order reinforces this predetermination as the order references no person present at the meeting by name other than Attorney Bumpus or Lil Woody. Fifth and finally, the court was visibly impacted when it learned that Attorney Steele had been informed of the meeting. And I do remember seeing that. Like, we saw the judge's face. He was visually upset. The Georgia Supreme Court referenced an opinion echoing this case in noting a recusal motion clearly has merit. It says, but what if the motion to recuse has merit? What if the judge who announced an oral ruling or reasonably appears to be partial or prejudiced and therefore has no business continuing to preside over the case? See Georgia Code of Judicial Conduct Rule 2.1. What if, for example, a party defending himself at a contempt hearing turns around and accuses the judge of prejudice, and the judge actively defends himself and then orally holds the accusing party in contempt? They're also saying, it looks like they're citing a case here. It's explaining the argument over recusal issues may draw the judge onto presenting his side of the story, which in turn may create a perception that the judge is an advocate or hostile witness rather than an impartial adjudicator, right? The alleged contempt is not ongoing and does not require immediate resolution. This court has ample time to transfer this case to another judge who is not involved in an ex parte proceeding, who is not a potential witness to a potentially disputed evidentiary fact, who does not view the harm to be, at least in part, a direct harm to the judge personally, and a sanctity of the judge's own chambers, and who is not called to determine whether the court's own security personnel or reporter committed the alleged contempt, and if so, what punishment.
So, hold on real quick. Shout out to Just Ani. She got a question for me real quick. Let me blow it up so I can see y'all. So Just Ani asks, can you share what makes you so interested in the trial? Yeah, what makes me so interested is I'm not even I mean, prior to the trial, I was not even a Young Thug fan or nothing like that. I wasn't into mumble rap or none of that. But I started watching a while back, and I saw how the court was treating them, and that's a big issue to me. Like, it's so many of us that go through court, and I've been in situations myself, and they just railroad you. Like, how can you ever win in court if the judges will get you? So this is a perfect trial. There's no bigger example that I've seen to this day that shows how biased the courts are. And if it wasn't this big, they would have easily railroaded them. The only reason it's so famous is because of the publicity it's getting, because of how many people is watching. So that's what makes me so interested in it, is that it's a full public view of what's happening behind the scenes, how cops lie on us, how judges lie on us, prosecution lie on us, and they lock us up and put us behind bars with no real justice, no due process. And this is a prime example, and it shows what's going on all over America, not just in Georgia, not just in Atlanta, not just with Young Thug. This shit going on all over America. That's what makes me interested in this case. So thanks for asking. I appreciate it.
To impose. That's actually such a great point that Kayla's team has put up here, right? What are they talking about? And when we're looking at this, what they're actually saying, looking at this paragraph, is that Judge Glanville took this personally. Judge Glanville, like, they're using physical evidence. Like, it's all on video. We saw how offended he was, that Brian Steele knew what was going on, right? We looked at the paragraph above, right before Lee took off, but we looked at the part where he said the word she. This was a personal, a point out from Judge Glanville. He knew it was Bumpus. I knew it was Bumpus. I had an idea it was her. I was just like, man, it seems a little interesting. When she was on the stand, the day that she was wearing the green, you guys remember? When she was wearing the green, he had asked her a question, and she said, I don't want to say it in open court. For me, that's when I knew, all day. And when both her and the prosecutors approached the judge, that's how I knew, all day, every day, So super interesting stuff. But what I think is interesting is that they're saying that Judge Glanville, he's taking this personally, a direct harm to that judge. So really, really interesting stuff. Let's move on. Her third part of the argument says this court must provide a notice that fairly and fully informs the accused of the specific acts of contempt. When a contempt proceeding is criminal, a full, I cannot read today, guys. I'm still tired from yesterday. A full panoply of constitutional protections must be afforded to the accused. They're citing a 2009 case, a 2008 case, 1985 case, and a 1992 case. So there's 5 cases in there. This includes a notice of fairly and fully informing the accused of the specific acts of contempt. Basically, those 5 cases are being used because, whenever somebody is accused of being in contempt, they need to learn about it, right? You got to give them notice. You got to give them time. This requirement of reasonable notice in a case involving an alleged indirect contempt contemplates and necessitates a written notice fairly and fully informing the accused of the specific acts of contempt with which she is charged, and so given as to afford a reasonable time to make her defense. Any notice short of that would make a hollow mockery of the fundamental and abiding truth that reasonable notice to one whose civil rights or personal liberty may be affected is a cornerstone of our judicial system, and would constitute nothing more than an exquisite exercise and frustrating fuel to, oh my gosh, who wrote this? Sometimes misleading and always meaningless, and would not be but sounding brass and okay. All right. Basically, they took this entire paragraph from this case right here in Ray Harris. That was written horribly. And that was a 2008 case. I don't know who wrote this paragraph, but basically what they are describing to us is what contempt is, right? And they're talking about when you don't have notice, when and what is notice really? Notice is when you guys are, you're put, like if you're put on notice, like when you are in trouble for something, you're notified of that, right? You have ample time to respond to that. What we're seeing here is Kayla's team is arguing, hey, I did not have time to respond to this. Like think about it. Right when they were looking for the mole, right when Woody said she's fired, right? Judge Glanville looked at Woody and said, Woody, listen, you have 10 days to think about your decision, to think about what you want to do, and then she can withdraw, right? Do you guys remember that day? And they came back from lunch. She had Woody sign a form saying that he wanted to release her, and that form was given to the judge. In turn, Judge Glanville then gave her the notice to show, the order to show cause invitation, right, so to speak. He filed that document. That's why he was late coming back from lunch, all types of shenanigans. That's when she was put on notice. Her notice was right there. So I don't like this paragraph, the way that it's framed, because it's kind of confusing. But basically, with contempt, she needs time. Like, look at Brian Steele. Brian Steele didn't have time. Ashley Merchant made the same argument. She made her same argument, and that's on appeal right now. Like all crimes, contempt has an act requirement. This is the actus rea, and a mental component, which is the mens rea. And it's so timely because Arturo was just talking about this. The notice alleges an actus reus, so disclosing the ex parte meeting, but fails to put attorney Bumpus on notice of the mens rea, that or how the disclosure would know such an act amounted to contempt. The notice does not allege facts from which a contemptuous mens rea can be inferred. So whenever a crime is committed, there's two parts of it. There's the action part of it, and then there's the thinking part of it. The thinking part of it is really what we refer to as intent. So you have to intend to do something, right? You need to have those thoughts behind your actions, and they need to be coupled together, right? It says here the notice does not allege facts.
Okay, again, this is a playback that most people have seen. So if it's going too fast for you, there's a settings button on your YouTube where you can slow it down, and it'll play slower for you. But it's already a recap, so most of us are already seen this, and I'm just trying to speed through it so we don't be here all day. But I appreciate you for being here. Appreciate you for watching. Hit the like, hit the subscribe, tap in. And yeah, if you want to slow it down, there's a settings button right on your YouTube. You just click it, and you can slow down the playback speed. All right, thanks for watching, family.
From which a contemptuous mens rea can be inferred. So what Kayla's team is arguing here is that you don't have the thinking part of it. You don't have the intent part of it, right? You don't have that part in order to put somebody into criminal contempt. As set forth above, the act of disclosing the meeting to defense counsel cannot in and of itself amount to contempt. The disclosure could only potentially amount to contempt if it violated a court order or some other legal duty to not disclose the ex parte meeting. The notice fails to allege any such restriction. As such, the notice fails to fairly and fully inform the accused of specific acts of contempt. Here's where we land the plane, guys. Wherefore, Attorney Bumpus moves this court to 1. Quash its order to show cause and or the alternative. 2. Recuse itself from this proceeding or transfer this proceeding to another judge whose impartiality can't reasonably be questioned. Or in the alternative, 3. Provide adequate notice that fully and fairly informs Attorney Bumpus of the alleged contempt. And 4. Should all of the above requested relief be denied, Attorney Bumpus requests a certificate of immediate review. So that's what Attorney Bumpus was asking for. It's 4 things, right? The first thing that she wants is to quash the order to show cause. That means that she wants the order to show cause to basically be canceled out. We don't need it, right? I need you to quash it. We don't need that. If you're not going to do that, let's move on to 2, which means Judge Glanville, you need to recuse yourself from this proceeding. You should not be the person that runs that proceeding on the 25th. So if you're not going to quash the motion to the order to show in order to show cause, then the second option, Judge, is for you to recuse yourself, right? Or transfer this to another judge who is impartial, right? And if they're not involved, if they don't know what's going on, if it's being transferred to them, we can't question their impartiality, right? Because they're looking at it with fresh eyes. And then option 3, Judge Glanville, if you're not going to do that, then at least give Kayla Bumpus an adequate notice that fully and fairly informs her of what she did. Fairly and fully informs her of the alleged contempt, right? She hasn't received that. And if you're not going to do that, then she wants this to go up for immediate review upon appeal, right? We saw a gentleman.
I'm the gatekeeper.
These particular cases, represent people in any trial of these cases. So, yes.
When I'm going to talk a little bit more about one last thing that Chairman Pitts mentioned at that quote that I read to you. The reason is they can do what they choose to do because the public doesn't care. So I was like, what do you mean the public doesn't care? And he says the public doesn't give a damn. It's the public's fault for re-electing them. He's talking about judges he believes aren't doing their fair share of work, which a response to him putting the blame on the public for for electing the judges that aren't allegedly doing their job.
Well, that's his opinion, but as I mentioned earlier, I mean, we all are working collaboratively, and I think it's a group responsibility for all of us to continue to work as hard as we can, to deal with the overcrowding issues and to work hard so that criminal cases get the constitutional requirement that they are supposed to get. So I think that we're working as hard as we can as judges. As I mentioned, there are unique challenges for the trial of criminal cases in terms of just scheduling, and then our ability, and then the reality and pragmatism of moving those cases, given some of the issues we talked about in terms of the availability of counsel, the availability of testing and lab results, mental health struggles, and then the fact that it's time over people, because I can only try so many cases per month. And I know that all of our judges are working very hard, as well as our prosecutors and defense attorneys and conflict defenders and private counsel, to resolve the trial criminal cases.
Do you think the county needs a new jail?
Yes. Yeah. We need a new jail. I mean, it's we have 1,100. It was built, like I said, in 1989 to house 1,100 people, and due to population.
Indicated it will potentially use interviews and property of Mr. Walter Murphy, which is what we're talking about, as exhibits at trial in the above referenced case. Then I wrote, Mr. Williams respectfully request that, well, I wrote, without Attorney Hudson, becoming a witness in this case, Mr. Williams respectfully requests that these portions and any other similar portions where non-testifying third parties make statements on the recording be redacted. This includes, I also wrote, any jail calls. The admission of any non-testifying third party at a proper setting or meetings with the police violates Mr. Williams' constitutional rights and Confrontation Clause, as well as inadmissible hearsay declaration. You granted the state today, and I'm not casting aspersions, when they gave the redaction, I was surprised, because all this that I have in there, except for the Brady and except for the Mr. Copeland shot the man, it's Mr. Hudson. You've already ruled it out. So for the state to say, and I'm not saying they're saying it wrong, maybe they forgot you ruled, but those are all the issues. Mr. Hudson and Detective Dennis, I know you haven't seen it. I guess they're friendly. They get into a major discussion throughout this interview. That's what I flagged. I wasted my time today to do what you already ordered because you want to have it in writing, and I'm trying.
I understand it. And
that's it, and that's all that there is. So for the state to say they got it today, or there's conflict, it's not conflict. Mr. Sharp, Mr. Harvey had issues. I had these.
Yeah, I did rule upon that earlier, State. So I mean, in terms of statements involving Mr. Hudson. So,
Your Honor, I think the court should. I'd ask that the court respectfully look back, be carefully. Ms. Hilton was here that day. I was not, I believe. And Your Honor, the court, Ms. Hilton took diligent notes about what was to be excluded. I believe that the resolution to what we disagree on would be sought in what the court said on the record. We took out the portions that the court ordered that we take out. Respectfully, Your Honor, I'm certain that there are areas where people can disagree, but I do know that we have been working very diligently to get those redactions done at her urging, as she was the one here listening to the court. So I'm not certain if there was a miscommunication, if one lawyer heard one thing and another heard something different. Perhaps the answer lies in the record itself. But we took out the portions we were ordered to take out, and as it relates to other matters, Judge, we do not have an agreement. We cannot agree on what we firmly, the court said that we should recognize things that might be a problem. We did, and we don't disagree on those. But the portions that are absolutely not impermissible, Your Honor, and that are only brought to us as a problem, the night before.
Her bullshit meter ringing like a motherfucker, huh? Let me fast forward this shit.
The witnesses to take the stand and literally verbatim ask Mr. White, over no objection for either of the defense, these exact statements, and now they want to keep. And so, Your Honor, I'm begging the court not to hamstring the state and leave it in the.
I'm not trying to hamstring you, madam, but I want you all to be prepared. It's ridiculous.
And we have been, and we literally told them last night we are sending over this final redaction.
But I do not.
And then we get this whole list of things. I mean, it's disruptive. We get it at 9:46 at night, and it's not fair to anybody, frankly. The defense, the state, the jurors, the court. It's not fair to anybody.
Well, stop doing it then. I mean, that's the thing. Stop doing it.
And we have anticipated a lot, but the things to anticipate.
To
anticipate, Your Honor, not.
Madam,
Yes, Your Honor.
I'm kind of I'm tired. Okay, I really am. I really am. Mr. Sharp.
gonna try not to belittle the point, but we at this point we have filed motions, and I have been filing motions the day before, and Your Honor has said certain things to me, and I accept that, and I'm not complaining to the court, but the things that I filed in those motions are legal arguments that I never thought I would have to make because I did not think the state would ever try to admit such evidence. Because we have all gone to law school, we all know what hearsay is, we all know what inadmissible evidence is, we all know what irrelevant evidence is, we all know that we wouldn't play recordings that talk about unrelated crimes, wholly unrelated crimes. We all know that we wouldn't play recordings where people say what other people said. So that's, respectfully, Your Honor, and maybe I haven't articulated, that's why I haven't filed these motions. But when I see the state put in their anticipated evidence coming forward through Investigator Dennis, a PowerPoint presentation that is just full of hearsay and full of incomplete, irrelevant, extraneous information, then I actually was put on notice at that time. I said, the state really thinks there's no rules to this, so I really need to start flagging everything. I was not trying to be disrespectful to the court by waiting to the last minute. I didn't think it was necessary to say, I want the state to follow the rules of evidence in the presentation of this case. I am now on notice, and I will be flagging everything I can think of and try to have a happy judge because you will be a forewarned judge. But I want you to understand that that's where I'm coming from. And so a lot of these things, I just didn't think we'd need to argue about.
All right. Let me hear the statement, the audio from 11 to 13:56.
I'm the gatekeeper.
Mr. Montgomery, I'm now showing you what's been admitted as 4 Bravo. Bravo, who is that?
It's me.
You're gonna have a representation of yourself?
It is.
Is this after you were shot?
Yes. I think so. I'm not sure.
Permission to approach, Your Honor?
Yes.
Mr. Montgomery, do you recognize this photo? Stacy.
Can you hear me okay?
I can.
All right. Just have a few questions for you, please, about what you just testified to. If I heard you correctly, you talked about the day that this incident occurred back in 2015. Is that right?
Right.
Okay. And if I heard you correctly, your testimony was that you remember on that day that you woke up in your house over in Lakewood, correct?
Right.
And your testimony is that you were at some point going to go to the store to get something for your grandmother. Is that right?
Right.
And you were going to go to the Citgo
Right.
to get that item for your grandmother.
Right.
Do you recall what it was you were supposed to be getting for her?
No.
Okay. But you do recall that that's where you were going to go and get it from the Citgo. Is that right?
Mm-hmm.
Okay. Is that a yes?
Right.
Okay. You said Neil was at the house.
Right.
And there were other individuals at the house as well. Is that right?
Right.
Now, you got in a vehicle. Is that correct?
Right.
And is it your testimony that you got into a Camaro?
Correct.
Okay. Were you driving the vehicle or were you a passenger?
I was a passenger.
You were a passenger in the vehicle? And you went to the Citgo where you were going to go get that item for your grandmother. Is that correct?
Correct.
Now, do you recall how many people were in the car with you?
No.
Okay. And do you recall anyone in the car having any weapons, any guns?
No.
When you got to the Citgo, am I correct that you never exited the car to go into the Citgo?
Correct.
Okay.
I never even made it to the Citgo.
You never got to the Citgo?
No.
Is it your testimony that this incident occurred, you were shot before you even got to the Citgo gas station?
Correct.
Do you remember exactly where you were when that actually happened?
On Browns Mill Road.
Okay.
Going up Browns Mill Road towards Jonesboro Road.
Okay. So you drove from where you were originally going up Browns Mill Road, correct?
Correct.
And at some point before you got to the sit-go, there was a shooting that left you injured.
Correct.
All right. D'Angelo White. Who is D'Angelo White?
I have no idea.
Okay. Do you recall that at some point after you got out of the hospital, you had an interview with some police officers by the name of Gaither and Dennis? Do you remember that at all?
No.
Okay. Do you have any recollection of at least Atlanta police detectives coming to your house and asking you questions about the incident?
No.
Do you have any recollection whatsoever of meeting with anyone at your house and indicating that you had absolutely no memory of anything that happened on that evening, either before, during, or after the incident?
No.
I understand that you don't have a lot of memory about what happened after the incident occurred, after the shooting, but would I be correct that your memory is fairly clear about what happened prior to?
No, you wouldn't be right.
Okay. But you are certain that this incident happened before you got to the sit-go, is that correct?
Correct.
Okay. Do you recall prior to getting into the vehicle whether or not anyone got into the vehicle with any guns?
Nobody. Not that I know of.
Did I hear you say earlier that you are not familiar with the name DK?
Yes.
Okay. Do you have any recollection of being asked by anyone with the Atlanta Police Department about DK and saying that you had heard that name before?
No.
Yo, shout out to Julie Horn. She says he was shot by one of Young Thug's childhood friends that served time for this, but they are charging it in this RICO against Young Thug because they claim it was for the gang. You know, when they was playing this, I was kind of confused. I was wondering, like, are they talking about a different crime? Am I tripping, or was they talking about something else? I don't know. Y'all let me know. It seemed like two different situations because the stuff that he was admitting to was not the same. It didn't sound the same as the case they was presenting. Like, he didn't agree with most of the shit they said. He was like, no, but it could just be because he got the shot in the head, but I don't know. Y'all let me know. But shout out to Julie.
At any time after the incident occurred, were you asked to come to court in regards to someone named DK being related to or connected with this incident?
Not that I can recall.
Okay. Did you ever have any communication with the district attorney's office prior to the past few months or so?
Yeah, I do.
Okay.
They came to the house.
Okay. When was that? Recently?
Maybe about a month and a half ago.
Okay. No time back in 2015?
No time back in 2015.
Okay. All right. One moment, please. Thank you. I think that's all I have.
All right. Anyone else?
No.
Anything?
No, I just...
20. Thank you. I think that's all I have.
All right. Anyone else? All right, Mr. Matthews.
My bad, y'all.
Good morning, Mr. Montgomery. My name is Carrington Matthews. I represent Mr. Huey in this matter. Back in 2015, 2016, is it your testimony?
Yo, shout out to Julie. She say DK the one who shot him. I definitely believe that. I definitely think DK was the one that pulled that trigger that night. But he was blaming it on the driver. But they was all confused. This shit was crazy. But I do agree that DK is the one that shot him.
Testimony that you were not contacted by any member of the district attorney's office concerning any other case that involved you?
Right.
No one contacted you to talk about any resolutions?
No.
No one contacted you
No.
regarding
No.
anything?
No, I just said no.
Okay. Thank you, sir.
All right, Mr. Sharp.
Sir? You mentioned a cousin named Neil that was in the car. Neil?
Okay,
Is that correct?
correct.
What is Neil's last name?
Davis.
And where is Neil Davis right now?
I have no idea.
Is he in Atlanta?
Yes, I think so.
Okay. All right, thank you. I have no further questions.
Anyone else? Any redirect?
Just briefly, Your Honor.
It ain't over yet.
Mr. Montgomery, I forgot to ask you, can you tell the jury where you got shot? What body part?
My head.
Okay, can you show the jury the portion of your head where you got shot?
Where the den is. There's no skull there.
Now, you mentioned you drove it, you guys were in a Camaro. Is the Camaro your memory today?
Yes.
Mr. Montgomery, how has being shot affected your memory today?
It makes me not have one. Makes my memory go in and out.
And do you remember leaving the sit-go and then getting shot?
No, I told you we didn't make it to the sit-go. We got shot before we made it to the sit-go.
They didn't make it to the sit-go? They got shot before they made it there? So that wasn't them in the video at all? Is that what he's saying?
And your memory today?
It makes me not have one. Makes my memory go in and out.
And do you remember leaving the sit-go and then getting shot?
No, I told you we didn't make it to the sit-go. We got shot before we made it to the sit-go.
Permission to approach, Your Honor?
You may, sir.
Mr. Montgomery, may I approach? I'm showing you what's been pre-marked as State's Exhibit 4 Bravo Bravo Alpha and
The old
4
picture.
Bravo Bravo. Do you recognize those photos?
That's me.
Is that a fair and accurate representation of yourself?
That's me.
Is that a fair and accurate representation of you?
Yeah, that's me.
What about this photo?
That's me.
Which one are you talking about, this photo?
4 Bravo Bravo.
Okay,
Your Honor.
all right.
That's fine. That's it. Actually, there's more than one. Yep, two. Thank you.
Mr. Montgomery, I'm now showing you what's been admitted as 4 Bravo Bravo. What is that?
That's me.
Fair and accurate representation of yourself?
It is.
Is this after you were shot?
Yes.
That me.
I think so. I'm not sure.
Permission to approach, Your Honor?
Yes.
Mr. Montgomery, do you recognize this photo? State's Exhibit 84 Bravo Bravo?
No.
No further questions, Your Honor.
All right, read the question, she said. Mr. Adams?
Hey, Judge, just one or two last questions. I think I heard you say, Mr. Montgomery, that the DA's office spoke to you recently or within the past few months about the case. Is that right?
Wrong. You can hear me say that.
No?
No.
Okay. Well, let me ask you this. They didn't contact you back in 2015.
He said, no, you didn't hear me say that.
Is that right?
Right.
Did they ever notify you that the person who was convicted of shooting you, Mr. Walter Murphy, they struck a deal with him?
No.
They never told you that either?
No.
All right. Thank you.
Anything further on behalf of any other? No. Next case.
I'm the gatekeeper.
It's funny right here, passing out Ricos. You get a Rico. You get a Rico. You get a Rico.
Grab. But
I just want to know, Hillary, when they finally arrest me with all the pedophile shit I do, how does a brother survive jail without being Epsteined?
Well, since you have a lot of shit on us, we're probably going to get you Epsteined as soon as you go to sleep. But hey, at least you won't have to shower, am I right? So anyway, enjoy your last meal, Puffy.
Looking like Christian Combs is getting remorseful and doesn't want to
Did you all attempt to send me independently another a copy of that, or?
We did not, Judge.
Okay, no harm, no foul, no. So no, I just wanted to know if you had attempted to do so, because we would have certainly, had we known that, pulled you in on Monday morning, which would have been the closest time that I could have heard your particular motion. So just from a time aspect, I just wanted to account for that. Taking a look at, and this applies to both motions that have been filed to recuse the court or disqualify the court. Recusal by a Superior Court judge is governed by Uniform Superior Court Rule 25, etc. Rule 25.1 provides that all motions to recuse and disqualify a judge presiding a particular case or proceeding shall be timely filed in writing, and all evidence thereon shall be presented by accompanying affidavits, which shall fully assert the facts upon which the motion is founded. Filing and presentation to the judge shall not be later than 5 days after the affiant first learned of the alleged grounds for the disqualification, and not later than 10 days prior to a hearing or trial, which is the subject of the recusal or disqualification, unless good cause be shown for the failure to meet such time requirements, and that is cited in Georgia Uniform Superior Court Rule 25.1. So I'm applying that to both sets of motions to recuse. And applying this rule, Georgia courts have held that when a motion to recuse is filed, the trial judge shall immediately, 1, determine the timeliness of the motion, 2, the legal sufficiency of the affidavit, and 3, the legal sufficiency of the grounds, and has no power to do anything else, and that is Robinson versus the state, 332 Georgia Appeals at 242-41. The 3 threshold determinations that the trial judge must make in regard to a motion to recuse are whether it's timely filed, whether the affidavit made in support is legally sufficient, and whether some or all the facts set forth in the affidavit are true. Recusal would be warranted, and that is Dacker versus the state, 300 Georgia 74-77-2016. The judge finds any 3 of the conditions have been met. No, I'm sorry, take that back, strike that. If the judge finds that all 3 conditions have been met, he must refer the motion to another judge to hear the motion, but if any one of the conditions is not met, there is no error denying the motion. And motions to recuse are viewed and considered by the appellate court for abuse of discretion. Accordingly, the court is going to address each one of the factors as it pertains to both Mr. Steele's motion and, for shortness, Mr. Banks' motion. I find both motions were timely filed. I find that Mr. Steele's motion was in fact filed on this past Monday, which would have been the 17th of June. I find that Mr. Banks' motion on behalf of Ms. Bumpus was timely filed, as it was filed on the filed on the 14th of June at 10:40 p.m. Secondly, I find that in addressing the legal sufficiency of the affidavit, that means was it sworn before a notary is in proper form. I find Mr. Williams and Ms. Bumpus's motions to be, or I should say affidavits, to be in proper form. The third thing that the court has to review, and like I said, I reviewed, is the legal sufficiency of your grounds of the motion. And here's where the court finds that upon a review of Mr. Steele's motion and affidavit, as well as Mr. Banks' motion and affidavit, that both contain assertions bare assertions and legal conclusions which aren't sufficient for the court to grant your motion at this point in time and refer it to another judge for it to be heard. So I'm going to deny the motion at this point in time. I invite you all to look at Baptiste versus the state. Just because adverse rulings have been made doesn't mean that the court stops the trial. So I'm going to make that. I'll reduce both of your
I'm the gatekeeper.
Of the motions to recuse to an order, and I will file that so you can take whatever steps you need to necessarily after that. But I don't get into anything about the affidavit itself, argument on that. I just have to read it. Those are only 3 things I do. And then if I find it to be not sufficient on space, I go for it. I just make the ruling at that point in time and let you all take it up. No, I won't grant a motion for a certificate for immediate review. And that's where we are at this point in time. Anything else, Mr. Banks?
If I could just briefly be heard, Judge.
Sure.
And I'm not trying to. I understand the court's ruling and we'll proceed as we see fit. I do take issue with the court's characterization about the legal insufficiency of the affidavits.
Well, that's why when it was reviewed on appeal, sure, it can certainly be. I mean, the appellate court will review my ruling for abuse of discretion.
Certainly understand that, Judge. And in stating that, Judge, I would just say that one of the issues that is raised in our affidavit, because our motion to recuse is to recuse you from the contempt proceeding, not the underlying criminal case in which Your Honor is presiding. And so we really don't have an issue or standing to even challenge that. And so to the extent that there is a contempt proceeding that is set for the 25th, Your Honor, you are a witness to that proceeding. And so because you were a witness.
I don't believe you. I'm not going to get into any argument. I can't. So that's your assertion at this point in time. And like I said, when that is taken up, I'll consider it. I also remember I still need to rule on the issue of the motion to quash. So I may, depending upon what I decide to do at that point in time, sure, other things may be ripe. Okay?
Do you want to hear about the motion to quash, or you want to take
No, not yet, sir. I'm going to take up the motion to quash after I finish. We finish the direct of the current witness.
Okay.
And to other issues that have been raised, as I've told some of the other lawyers here, there is a transcript of what occurred in the ex parte matter. I will, in fact, I'll authorize defense counsel. I'll do a privilege review and see what needs to be disclosed in terms of impeachment and/or Brady, and for that, and I will do that. And then so if that issue affects you, then certainly that may be something that at the appropriate time you'll be able to have a look at.
Well, I appreciate the court's time. We would certainly rely upon our brief and our motion, and that's a part of the record.
Okay. All right, but I will reach out. The court will reach out to you on 2 things. One, the ability to take a look at the ex parte transcript and review it for the appropriate parts that the court will authorize. And then also for I'll re-notice you because I know that it's supposed to be done this Tuesday, but I doubt that we'll probably have it this coming Tuesday.
If I just may say, again, Judge, I know I've already said it as it concerns the issue about you being a witness to the proceeding. We don't believe that that's a bare allegation. We believe that would be an established fact at the hearing. We also.
But I can't take it. It's not something that I can argue with you at this point in time.
I'm not trying to argue.
No, sir. You are an advocate for your client. Sure. That's the only thing I can say, but I'm not going to take up that issue right now. It's part and parcel. You've made it part and parcel of the motion to recuse. So I'm saying that at this point in time, I've made my ruling. You've said what you need to say in terms of what your thoughts are. I'm going to reduce it to an order, and you can take what you want to after that. Okay?
All right. Thank you.
All right. Thank you, sir. All right. Mr. Steele, similarly, I'll reduce what I have mentioned to in an order, and you will be able to take it up as you see fit. I'm not going to grant a motion to a certificate of immediate review. Anything else?
I have read Baptiste versus State. I've read all the cases that I believe are applicable. Best I can. But specifically, if the court would reconsider And if nothing else, the Honorable Keith Adams and my joint affidavit in paragraph 12, we assert not a bare assertion or a legal conclusion, but we make facts that we specifically adopt from the Honorable Attorney Winchester, Collins, Banks, Nove, and Mormon's motion, where a person that they represent was in a meeting, ex parte, with the court and others, and the prosecutor and a witness, and specifically, they wrote in a pleading and under Parish, which is P-A-R-R-I-S-H versus State, which is 362 Georgia Appeal, 392 Division 1, 2022, the lawyer's pleading on behalf of the client becomes a statement of the client. And they said that this court got involved with speaking with Mr. Copeland and assisted in Mr. Copeland testifying against Mr. Williams. So I've added this court to the witness list. I plan on calling the court as a witness in the trial. I added lawyers Hilton
Why this
and
nigga
Love
always coughing in the
from
mic,
District Attorney's
too?
office to
That
the
shit
witness
is
list.
fucking annoying.
And when I
Coughing,
cross-examine Mr.
sniffling,
Copeland, when
sneezing.
that day comes, I'm going to ask him about how much pressure, if any, the court put on him. And you're going to be the one instructing the jury. And I just can't imagine how that's fair to Mr. Williams. So I just ask you, I'm not abandoning anything in the joint affidavit from the Honorable Attorney Adams and myself, but if you would just look at just even paragraph 12, again, if you didn't consume it entirely, I don't believe that meets a legal conclusion or a bare assertion. I ask the court to recuse.
I've read your affidavit, Mr. Steele, and I've consumed everything on it, and that doesn't change my ruling at this point in time, respectfully.
I also, on the transcript, I'd like the recordings and the transcript, and I object to the court going through it and deleting it, because to me, the way I understand it, there is zero privilege. So I don't understand
I'm
how.
not going to, Mr. Steele, I can't argue with you about anything such as I've made my ruling, okay? If you have some other basis to ask for the recordings or anything like that, you're going to have to put those in some other pleading. But at this point, Ms. Weaver's going to prepare the record. She does that. And like I said earlier, the record should be ready soon. And you all, as a defense group, will have the opportunity to take a look at that particular ex parte transcript that was done in chambers, less anything that is totally, that the court considers to be privileged. And I'm going to let you do that before you examine Mr. Copeland. So you'll have everything that you have at that point in time.
Thank you.
All right.
Real quick, shout out to Reggie Righteous. You right. Shout out to all the new subs. I appreciate y'all for coming in and tapping in. Hit them subs, hit them likes, hit them subscribes. And Julie is absolutely right. He does that on purpose because he knows every time he crunch, every time he sneeze, every time he cough, we lose about 1,000 views. Like about 1,000 people log off just because he's sneezing and coughing. So he definitely do that on purpose. But we still here. Tap in, tune in, turn on. Let's go, family. Much love. We almost done. I'm wrapping it up right now. I'm going to play maybe one more video after this.
Okay. All right. Let's turn now to the statements or interviews from January.
That finishes our business today, man.
You don't want to stick around? Okay, okay. Well, okay, thank you, Mr. Banks. At all. Okay, all right, okay. Yes, you may be excused, sir. All right, Ms. Hilton and counsels, what matters do you have to take up from the interview from the the January 28th, 2015 interview?
Your Honor, last night we sent over both the February 21st and January 28th redactions. We sent the February 21st one around 7 p.m. and then the January 28th probably around 11:30. We have not heard from defense counsel yet.
Miss Hilton, they about to change her name to Miss Motel 6.
I'm not sure if they've reviewed them and if they have any additions or disagreements. So we were just waiting for defense counsel to let us know their position.
Okay. Counsels for defendants, have you identified, since now the state has sent you parts from the 28th January interview that you wish to talk about? Mr. Sharp?
Good morning, Your Honor. I have not had a chance to digest their proposed redactions. I'm happy to talk to them about it. I've been working feverishly on getting together the redactions that we believe are warranted. Again, I'd be happy to talk to the state about that. I'd also be happy to go through them one by one with the court, however is favored. But I can't say at this moment that we've cross-referenced the two lists.
Okay, all right, so that's what we're supposed to do this morning, though. So does anybody else have flagged or wish to be heard on the interview for January the 28th? Sure. We're going to cover them independently, like the January 28th, we'll cover the February 21st, and then we'll cover the June the 10th interview, and then potentially the jail calls.
I believe that myself and Attorney Steele may both have lists. I don't
May have what? Sorry, I'm sorry.
Lists.
Okay.
But we're representing different individuals, so the list may vary a little bit. So you may be getting some suggestions from this chair, some suggestions from that chair, and then some suggestions from the state.
I understand.
Yeah. Okay. Your Honor, may we have 15 minutes to...
I'm the gatekeeper.
All right, we got one more, family. Let me find it real quick, make sure it's the right one, and then I'll get it started. Appreciate y'all again for being here. Appreciate y'all for watching. Subscribe, hit the like, tap in. You know what it is. One more video. Just let me find it real quick.
Defense counsel to turn over to the state the file in the original condition that it was given to them, so that we may properly access and evaluate the content and the time and date and all of that, and the authenticity of those calls on that file. It has been deconstructed, and particular parts of the file have been extracted and purposefully kept out of what is given to the state. So we are asking, again, that the court compel either, you know what, and if they don't want to, then we're asking that they just be excluded.
Okay. All right, Mr. Steele, do you have the raw file?
Judge Glanville,
Sir.
you allow another moment when Ms. Love calls me that I did not do something. They have the exact image of what we got from the jail in Fayette County. That is it. And if I get another false allegation and you do nothing, I'm shocked. I'm appalled at you. I sit here day after day with this false allegation just machine. I gave the state everything. There's been no disconstruction. There's been no purposeful, I don't care. I don't care. I give over everything. I've done this for 33 years. Never in my life have I seen a trial. I've done 300 appeals in the state of Georgia alone. I've never read a case like this. Judge, I gave them everything I had. I waited. I was at my office till 8, after 8 last night. I waited for their investigator to come by. I handed him an exact copy of thumb drive. They have everything that we got from the Fayette County Jail. There's been no deconstruction. There's been no purposeful exclusion. This is not the first time.
Okay.
And I apologize that I'm getting tempered, but I've never been treated like this. You talk about professionalism every week. Professionalism is lacking with one lawyer here. It has never been. I don't even like coming to court. I used to love this. I would die for what we do. I used to say, I'm dying. I couldn't choose a better profession. If I had litigated with Miss Love, I would.
Your Honor, could we strike the
No,
ad hominem
I'm
attack?
speaking.
Really, could we strike
Okay, hey, everybody, calm down. Everybody, both of you sit. Both of you, please be seated.
Judge, I'm not
Both
done.
of you, please be seated.
You have to do something. You have threatened me with contempt. You have threatened me with jail. If you go back in time, we can just start in voir dire. Jury after jury, you did individual voir dire painfully. Miss Love would come in and say that juror was crying. It was not true. You would say, that's not my recollection after I said it. You did nothing. We start the case.
But Mr. Steele.
I asked you, please.
Mr. Steele.
Please, Judge. How would you feel if you were being treated
Mr.
like
Steele.
this?
Mr.
Well, I'd
Steele.
like to finish.
Mr. Steele.
I gave them everything on that drive, and it's continual abuse of a prosecutor, of another member of the bar. I don't talk with Miss Love. And that's fine. I like that. But, Judge, I'm not going to stand here anymore. I don't care. You can take my bar card.
Mr. Steele, listen.
Wrong, though.
But there.
And Mr. Williams, you know, to me, this is an innocent man. You talk about, Miss Love said there's a man in the Fulton County Jail. He shouldn't be there, Mr. Copeland. Mr. Williams shouldn't be in custody. But he's been charged, and we come here for a fair trial. It's been everything but that, according to Miss Love has tried to demonize me. At times, Mr. Adams. At times, Mr. Shaw.
I object to the ad hominem attacks, and I ask you to
all
restrict
because she wants to
again
win a
from the
case. And now she speaks over people. It's not right. I gave them everything. And by the way, and what I want to tell you, by the way, it's not even the law. If they call that gentleman on direct, I don't have to give them anything before trial. I do it because you asked me to. You said, listen, we got a big case. It's going to take a long time. Give them things. I gave this, by the way, to the state October of 2023. October 2023, that was uploaded. Given to the state. I hear about it now, and I wait there, and I give them the exact
Look at her neck. She don't even got to talk. She could just speak with her neck.
duplicate of what we have. You said, listen, we got a big case. It's going to take a long time. Give them things. I gave this, by the way, to the state October of 2023. October 2023, that was uploaded. Given to the state. I hear about it now, and I wait there, and I give them the exact duplicate of what we have, and now there's a false allegation of misconduct. And what I'm telling the court is what I said again. I do not appreciate it, and you have told it in front of the jury that I'm unprofessional. You were wrong. You based that on Miss Love's false representation.
Your Honor, again, the ad hominem attacks, Your Honor. I object, and he should stop talking when I
Miss Love can
object.
try to silence me. I will not be silenced.
But Mr. Steele, here's the thing. Okay, I think that Mr. Steele, please be quiet at this point in time. You made your point. You made your point at this point in time. Both of you, please be seated. Please be seated, sir. Sir, please be seated.
Whatever you do is fine, but I care about Jeffrey Wood. It's the best.
Sir, it's obvious. I would expect no less because you're his advocate, you're his champion. But could you all please sit down so I can kind of figure out a solution for this? All right. First, let me just kind of address the obvious. I know that at times tempers have been heated in this particular trial, and they continue to do so. And I know that all of you are being zealous advocates and representing your clients to to the best of your ability with zeal and rigor. However, I agree that, there should not be ad hominem attacks on anybody or any counsel, and that you all should think and reflect about what you say about your brothers and sisters of the bar. Because we have a large contingent of folks that watch this trial. And so not only for the purposes of this, but it sends not the message I think you want it to send. All right, so I'm going to leave you all to your wise discretion in order to do that, but I'll take up whatever I need to take up as I see fit. But I know that you all, this has been a long trial. It's very demanding, exacting, and grating on, and tiring on all of you. So I ask you to just take a couple deep breaths and step back and see, and kind of look at, and just remember that you do represent of who you represent and what you're here for. In terms of that's what you got, and I'm gonna take that at face value. I'm in no way saying that. Ms. Love is in her argument is saying that she is, when it's stripped down, less all the sound and fury, she's saying that particular type of file has other things with it. I don't think you were given those, and that's what she's trying to get. So I'm in no way blaming anybody in this particular circumstance, but if you want that particular file, and I think you all should have that particular, the raw file, then let me do a notice to produce or a rule nisi, and maybe we can get the entirety of the file. And I think that if you did that, I think that the whole thing would probably be produced to you, because nobody probably wants to come down here and see me. So I will work with you all to get that, and you all we can take that up, and it's a problem I think can be resolved. But I'm in no way. But I would just remind everybody to be careful about what they say to each other. Some things you just can't take back. And remember, y'all are going to see each other over and over and over again. And, it serves you and serves the profession, serves your clients. It's not effective. So just please consider what I've just told you. All right? So, I'm just going to recess, and we'll see where Mr. Melnick is at that point in time. And then I can talk about Monday for certain, okay? All right. Okay, I'm just going to recess in place. I know that you were here early, and I know why you were here early. Okay. So, but focus. The focus is on why didn't we file this stuff months ago, and let's wind it out and air it out at that point in time, okay? So, I'm going to ask the state their issue on this. Are you cutting this out? Did you have discussions with Mr. Sharp? Madam?
We did have discussions.
When?
Well, this morning.
That's too late. The evidence is excluded. The evidence is excluded. I'm going to exclude because I told you that this was going to happen.
We reached out to them.
No. We're excluding that, and I'm going to exclude the PowerPoint that you all submitted. Well, you're not going to wholesale introduce it.
We had no intention. Your Honor,
all right.
Let me just be real clear. We did not intend to introduce this PowerPoint today. I personally reached out via telephone and called at least 2 members of the defense team and asked them to call me back.
But you all should not be identifying this stuff the moment of trial while the jury's sitting in a box. This is the last. I am not going to tolerate this any further. If you don't get together with your colleagues and flag issues and resolve them promptly, and if I have to take them up, remember, I can exclude them. We'll work the weekends, or we'll do a combination of both. So this time, I'm going to exclude those 2 sections.
Your Honor, Mr. Atkins, he confronted this witness with those sections. I last week let them know that we were introducing that.
If the exhibit's not ready and you haven't made, no, well, Mr. Sharp's got objections to it.
But Judge, Mr. Sharp can get in and have our evidence excluded every day that he makes an objection at midnight, and then comes in and says.
Well, then you all should have gotten your stuff together before then. Some of our juries, please. Some of our juries. Have a seat, madam. Have a seat. You better exclude that, and next time, make sure you're prepared. Make sure you're prepared next time. I'm not going to do this anymore. I'm just not. We are starting right now. It's 1:20.
So we have talked to them. We have said we don't
then file a motion and get it before me, and we'll take it up. Both of you all have equally responsibility to do that. Oh, it's going to be inadmissible right now.
I'm saying, Judge, that you said to file a motion. There's nothing.
I'm not going to have any more discussion about this, madam. I'm not.
Talk to them this morning
I don't.
about that.
Well, you know what?
And I attempted to try to talk to them earlier this week.
Well, then that's why we have to.
Be honest, the court punishes the state because the defense.
I'm not punishing it. Prevents poor performance.
Be prepared, Judge. That's why I sent them what I sent them last week, a whole week and a half ago, 2 weeks. Your
I'm
Honor.
not. Well,
and I was asked. I said I would like to discuss.
Our jury's coming in, madam. Our jury's coming in. Have a seat.
Alright, I know I said it's over, but I'm gonna hit y'all with one more little bonus. This is a little separate. This is Cameron a while back, and this shows how biased they been now. Before I even play it, let me ask y'all one question. It was Terminator, you know, the one back in the days with Arnold Schwarzenegger. Was that a cartoon? Was that a cartoon, or was they really like shooting niggas with shotguns? Like real looking shotguns?
Thanks for staying with us. I'm Bill O'Reilly in the Impact segment tonight. Last week, the principal of John Reynolds Elementary School in Philadelphia, Salome Thomas L., told us he believes gangster rap music is extremely harmful to his inner city students. So we decided to get Grammy-nominated Cameron, who raps about pimping and bitches, and among other things, and rap producer Damon Dash, a co-founder of Rockefeller Records, together with Mr. Thomas L., who joins us now from Philly. And here they all are. Now, we're going to have a nice, intelligent discussion here, gentlemen, and I'm going to moderate this discussion.
Pimping and bitches.
Yeah, you know.
Pimping and bitches.
You got it in your record Purple Haze right here. But anyway, let Mr. Thomas L. direct his questions, and then you guys can answer, and you can ask him questions or whatever you want. Go ahead, sir.
Yes, good evening, gentlemen.
Hey, how are you?
Good. I'm a big fan of yours. I grew up on hip-hop.
Thank you,
I'm a little older, so, you know, I was a Run DMC fan, KRS-One.
Yes, sir.
But I'm always promoting the positive of rap. I mean, Jay-Z's an excellent example of someone who's hasn't started his own label, who's an entrepreneur. So always promoting that with my young people. But I spoke to some students today in preparation for our conversation tonight, and they were just so excited about the fact that I will be conversating with you guys, but also began to talk about the impact of the rap business on our young people, and many of them talked about how they understand that it's to sell records and it's for promotion, but there are many young people who are affected by the lyrics, by the example, the videos. They talked about how Ludacris, many of them knew about a video that Ludacris has where there are strippers and lap dances and those kinds of things, and these are 11, 12, 13-year-old students who are very aware of what goes on. And I was just wondering what your thoughts were on whether you thought you really had an impact on the lives of young people and whether you thought it was negative or positive.
Cameron, why don't you go ahead?
At the end of the day, yeah, you got an influence on it, but so do movies. Like with me, I'm just an author. So what I do is I write what goes on in the ghetto. I'm not a liar. So if what I tell you goes on in my album, that's what goes on in the streets of Harlem. Now I'm like a reporter. You look at the news, you don't get mad at the person reporting the news. A lot of influence, I think, go to movies. A lot of people look at the movies and then they react. The kids that killed them kids, and where was that thing? Like Columbine. Yeah, you feel what I'm saying? I don't think they were listening to rap at all. I think that was more like a Marilyn Manson jump off, like.
What if an 11-year-old kid imitates you, Cameron? What if he uses 4-letter words and he develops a lifestyle based upon the street? He gets tattooed. He gets all this.
Okay.
Let me just say, and then you can jump in. Do you feel badly about that?
No, I don't.
Can I maybe interject? If a 11-year-old were to imitate Cameron, what they would be doing is becoming the CEO of their own company, controlling their own destiny, taking a bad situation and making it good. He has a record company. He sold a lot of records. He's acted in movies. I feel like he's a positive.
Also.
He has a cologne.
I have a clothing line.
He's an entrepreneur.
You know what I'm talking about, David.
Well, no, he's an entrepreneur by his own right.
If you have a child who is unsupervised and then Mr. Thomas L. has to try to teach,
right,
and he's using 4-letter words inappropriately, he's dressing inappropriately, he doesn't have value of education, then that kid's in trouble.
Who's to say what's inappropriate as far as dressing goes? But on another level, when Arnold Schwarzenegger was the Terminator, he was shooting up half of everyone in sight.
It's a cartoon, though.
This
is more real.
The Terminator is not a cartoon.
This is real, though, isn't it?
Well, no.
In my life, everybody's rap is
This is real. It's not a Terminator cartoon. All right, Mr. Thomas L., what else do you want to ask these guys?
You didn't let me finish that. That wasn't very fair.
All right, go ahead. Go ahead. Well, let Mr. Dash finish.
Now, we're talking about the good governor of California.
That's right. And I'm telling you, his movie's a cartoon, whereas this rap stuff is real life.
But you said if
who
there's
are you to determine that?
Hold on, Ken. If there's an unsupervised child, how is he to know whether it's real or not? How is he to determine what's real and what's not?
He said a Terminator cartoon. Terminator was not a cartoon at all. See how quick they just lie? That shit is crazy. Like, they just act like they don't see the truth.
Not real. Who's the super?
All right, go ahead. Go ahead. Well, let Mr. Dash finish.
Now, we're talking about the good governor of California.
That's right. And I'm telling you, his movie's a cartoon, whereas this rap stuff is real life.
But you said if
who
there's
are you to determine that?
Hold on, Ken. If there's an unsupervised child, how is he to know whether it's real or not? How is he to determine what's real and what's not real? Who's to supervise him?
All right.
And
Do you think
they
that
get
the
way
Terminator movies are just as damaging or more so than gangster
I would have to
rap?
say, being that there's a visual and being there's no explanation to him, and being that
visuals on these rap videos too, though.
But what I'm saying is, it's glorified. There's no justification for all the shooting that goes on. So if he's reporting what goes on around the street, he's a product of his environment. Not to say him, but he's reporting what is a product of his environment. How is that wrong for him to report that?
Gentlemen, let's be honest.
Thomas, I'll get in here.
Gentlemen, let's be honest. Who do these kids relate to more? You, someone from the inner city, or someone from another country, or someone from the suburbs? Let's be quite honest.
Well, what I was
you came up the same way I did, the same way millions of these kids do every day. We're growing up in a fatherless society. We're growing up. A lot of our friends, your friends, my friends, didn't have a lot of supervision at home. Most of the time, they were at our homes. We had good parents. We had parents who didn't allow us to do or watch these kinds of things.
Right.
But these children, now, in the movie industry, believe me, I'm a critic of the movie industry also. I think that these kids are watching too much TV, period. But my issue is that when you rap about what these children relate to because it's in their environment. You've already stated that they don't know your story because you're a CEO, and I agree. But see, you don't promote that, and your company doesn't promote that. They promote the 4-letter words.
We don't promote entrepreneurship. We don't promote positive and ownership of your company. I'm making it cool to be smart.
All right.
I'm making it cool. Wait, let me explain. I'm making it cool to be a businessman.
It's not about business.
Not about business for you because you feel like it might give you better ratings to portray something negative within the image of hip hop.
It is negative.
It's not negative to be a businessman. It's not negative to take care of the economy around you.
It's negative to make money, Mr. Dash, if you hurt children.
How do you hurt children by promoting to be an entrepreneur and a CEO and to do right by?
You're looking at a principle.
For example.
Hold it. You're looking at a principle.
Why you don't want to let him talk? You mad? Where'd you start? Current affair, right?
No, wrong.
Well, you faked a lot. I got dirt on you, doggy.
Cameron,
I'm going to get at you in a minute.
You go ahead. You get at
I'm going to get at you in a minute.
Listen, you're looking at a guy who teaches inner city kids and who is telling you face to face that he has problems with kids based upon a rap music, and you're rationalizing it all up and down.
I thought you were going to mediate.
I am.
No, what you're doing, you're giving opinions. That's not. You're not objective mediator now, Bill.
It's my program.
Bill, now it's your program.
Bill, yeah, it's my program.
Bill, come on, Bill.
You'll have the dash factor some other time.
I have the dash factor.
Gentlemen, I
got a question for Cameron based upon what you just said.
Come on, let's keep it civil.
This is civil. Wait a minute, Mr. Raymond. Now, look, if the principal tells you that there are children in his school, Cameron, who are being adversely affected by your music, do you care?
I care, but you got to talk to their parents.
What if they don't have good parents?
While they're in school, they have to have parents to be in school.
Well,
Somebody send them to school.
No, they don't have good
Well,
parents.
listen, and if that's the case, homeboy, whoever's in my ear on the television, you need to have parent-teacher conferences with your students. Whether it's their aunt, their cousin, their sister, somebody send these kids to school. They're not 11 years old staying home by themselves. I can't go home and talk to these students at night. You need to have more parent-teacher conferences if you have problem with your students.
Let him reply. Let him reply.
And
Go
yeah,
ahead.
now they're turning their TV and
Let him
radio.
reply.
Okay.
Mr. Thomas L. reply.
That was a
good
point, Cam. Thank you.
Right. Actually, no, it's an excellent point. Actually, you are talking to these students because they listen to you every day. See, you are.
So I got more influence than their parents. That's a problem.
No.
That's a problem. That is a problem.
That is a problem.
So you need to have parents-teacher conference because these are your students. You feel me? I can't come if you want me to come to your school and talk to your students. I can do that. for you.
I don't. No,
All right.
I don't.
Listen.
Are you
have to talk to
the
the
other words?
Go ahead. Go ahead.
Are you going to come?
Let him get in.
You have to talk to your parents.
You're cutting me off, sir.
You're mad.
Go ahead, Mr. Thomas L. Go ahead.
No. What I'm saying to you. What I'm saying to you is that you're making millions of dollars off of these kids.
How you know
The
how
same
much I'm
kids that
making?
you're
How
now
do you know how much money I'm
denigrating,
making?
the same parents that you're now
How do you
denigrating,
know how
you
much
make
money
millions
I'm
of dollars
making?
off
How do
these
you know how
people.
much money I make?
Go ahead.
So
Now
let me
you
ask you a
reply.
quick question.
Go ahead.
I think it's pretty unfair for you to judge the circumstance without properly understanding it, but every opportunity we get, we try to say as positive things as we can, which is why when we do make these monies, we give back to a community. Me and Cam ourselves from 142nd Street to Lenox, we do have a program there that teaches the kids to be positive. We make them go to school. We support a basketball program, and every chance we get, we personally know 150 kids in the neighborhood and speak to them and tell them to stay in school and incentivize them to stay in school.
Now I'm going to take a break. I'm going to hold these guys.
About that?
Okay, I'm going to take a break. I'm going to hold these guys over for a recap. I'm going to let them all recap, and we'll be back with that in a moment. All right, we're going to continue now, and Mr. Thomas L., we're going to give you a minute to make a statement, and then we're going to go to Cameron, and then we're going to go to Damon Dash, and I think that's a fair way to do it. So you go first.
Okay. I'd like to thank you, gentlemen, for what you do. I'd like you to promote more to these young people, and maybe even if you can influence the folks who are around you to promote the positive things that you're doing. I know you're doing positive things. But also, these children are watching you tonight. Many of these children have parents who are incarcerated, parents who are drug addicted. They don't have the parental involvement they need. They look up to a lot of you guys. A lot of you are men. They don't have a lot of contact with positive men. And tonight, you're making a mockery of their situations. So, you know, tonight to an intellectual people, you didn't make rap look good, you didn't make the industry look good, and we aren't highlighting the positive. I'm hoping in the future that we can send a better message, not only to our young people, but to America, that this industry does have some talented people who do care, because you're out there doing some good and great things for young people.
All right, good. All right, Cameron, you go.
Cool. I just want to say I think that we got off to a bad start tonight, but I think everything that we said was very positive. I think that what me and Dash are doing is very, very, very positive for the youth. You just jumped on everything that we done bad, and there's nothing that we done bad. You took it based on one song of lyrics. Like, I think what you need to do is get more in tune with your students, you know what I mean? You need to have parent-teacher conferences. If you need some of these rappers to come in, call the record company, call Rockefeller Records, call Diplomat Records, and ask us to come in and speak to your students. We do
I
things
want
like
to call
that.
you.
No, your statement is over. It's my turn to talk. You're done for the night.
Well, you cut me off early.
No,
So I'm going to call you and
You're
hold
done
you to
for
your
the night,
commitment.
principal.
Mr.
Take it
Thomas,
in. Take it to school tomorrow.
All right,
You're done
good.
for the night.
If he needs you to come in,
Holla at us.
right?
Diplomat Records will come speak to his kids.
All right,
Purple
let-
Haze,
thank you.
February
Thank you.
17th. Go
Let
get
Mr.
it.
Dash wrap it
You're
up.
done for the night.
You go.
Going along with Cameron said, I think a lot of what we said was positive and informative. It's kind of obvious that maybe you don't understand that everything affects everything, whether it be movies, books, literature, a reporter on television. And if you're going to promote anything, I would think that to the culture, to the kids that are watching, you would promote the positive aspect of it. So if you know there is negative in something, try to find the positive as opposed to always talking about the negative. That's the thing I don't understand, why we critique so hard within hip-hop. No one talks about the jobs we create. No one talks about the things we do within our community. And no one talks about the businesses we've done, how we've opened the doors and shown people that it's cool to be smart, it's cool to be a CEO, it's cool to take advantage, not to take advantage, but to reap the benefits of all your labor and to do it fairly. I can't see how that could ever be considered a negative, and I'm disappointed in the fact that you would be thinking that.
All right.
But anyway, I just want to say one thing.
Quick.
Rockefeller.
Yo, once again, thank you all for tapping in. Thank you for all the new subscribers. Definitely appreciate it. 13,000 views. That's a new record. I appreciate y'all for being here. Appreciate y'all for tapping in. Yo, they wildin', right? We got to stop this. We got to do something about it. But our views and everything counts. We the jury right here. They can't fake the funk when we see it all. Usually they got it hiding behind the screen, but we see it all. So thanks again for everybody for tapping in. Thanks for all the new subscribers. Julie Nickel, Butterfly Moon. Shout out to the new subscribers. Who else we got? Lynn Jackson. Paulette Cournoyer. My bad if I bashed your name, but appreciate you for subscribing. AI, appreciate you. Who else we got? John Rambo. Sharon Coyston. Bangla Zwi Akona. Alicia Spencer. Joshua Rothschild. DJ Naptown. Appreciate y'all for subscribing. Appreciate all the new subscribers. Corey Baker and Eva Jordan. My bad if I missed y'all, but I appreciate y'all for being here. Appreciate you for tapping in. Much love, family. Until next time, we out. And before I go, big shout out to Julie Horn. She been coming through for your boy. Much love. Shout out to Reggie Righteous on the beats. Beats by Reggie Righteous. We appreciate you, fam.